Sudhakaran, Professor Thomas Andrews, fellow MCS members and participants. A hearty welcome to each and every one. This workshop marks the beginning of our ventures as mooters into a fresh academic year. We hope that this workshop helps you not only in your upcoming AMCC or IRA rounds, but the upcoming moots as part of the MCS panel as well. We wish you abundance of growth. We would like to extend our gratitude to our director for being our foundation at all times. We hope to have your constant support as we begin this academic year. Before we begin this workshop, I kindly request our respected director, Father Gerald D'Souza, SJ, to address the students and formally declare the MCS open. So please.
Thank you. A very good morning to all of you, and a warm welcome to this workshop as well. As you are aware, mooting or moot court is an integral part of legal education. Therefore, this workshop plays a very, very important role in our legal education, and especially at St. Joseph's College of Law. As you are aware, there is no shortcut for learning. Hard work is the only mantra. Therefore, we are teaching you, perhaps this workshop is taking us to that mantra back once again. Hard work is the only way to be the expert, way to be very competent persons in the field that we are aspiring to be. A few key elements of mooting or perhaps moot court that all the students need to keep in mind. First of all, the research is one of the most important components of this mooting and the moot court exercise. You need to search more, research, and perhaps search which is very much relevant to what you are going to speak, what you are going to communicate, and what you are going to convince in the court of law. Secondly, it invites us to improve our writing skills. Ultimately, whatever idea that we have, the concepts that we have, and the supporting documents need to be presented in the form of writing. And that is the requirement today. And that will be definitely dealt with in this workshop. Thirdly, it is the exercise of building confidence. When you are thorough, when you know your subject well, naturally you will be confident. Your body language changes, and the way you communicate will definitely depends on what you have and how you have done your homework. Therefore, this will definitely boost our confidence level and make us more and more competent. Fourthly, what is required is logical thinking. We cannot afford to speak layman's language, or perhaps if I allowed to say, you cannot afford to have a WhatsApp language in a legal language. Most of us are used to, and perhaps most of us are victims of this WhatsApp language. That is most unfortunate that is taking place in the modern day. We need to have that logical thinking. We cannot afford to speak what we feel like speaking, what we are comfortable at what speaking, but we need to be very, very reasonable, rational, and perhaps highly logical in our thinking as well. Fifthly, the application of law to a life situation. This is a different otherwise, we will have this dichotomy. We will be either highly theoretical or we will be only practical. This moot court exercise is just to bridge that gap, that we need to be able to apply the law to the practical situation. We need to be able to apply law to the day-to-day problems, day-to-day legal problem, or perhaps a social problem, whatever it is. Therefore, it is a skill to apply, a skill to interpret, and perhaps to see in the eyes of justice what can be interpreted in order to promote justice, perhaps, which we are looking at. Lastly, the teamwork is what is expected in this whole exercise. I was part of, perhaps I entered one class other day, And in one of the perhaps works, the concerns of the student was when they were given teamwork, people had a lot of reservation. Oh, teamwork, no, you give us individual work, we'll be happy. If it is a teamwork, there will be always people who are avoiding and escaping the responsibility. Therefore, let us not have that teamwork. This is the cry that is coming up more and more today. It's true, I understand we are claiming for our autonomy, autonomous space, and also a workspace where we are alone, where we are individuals. That is unfortunate today, and I think that should not take place. I think teamwork is must in all the field. It is not only in this moot court situation, even in our life as well. Secondly, what is also required is, a lot of listening is required. You need to listen to your opponent in the whole moot court exercise. We are into a culture of a monologue. We speak and we listen to ourselves, and we forget to listen to the other. Perhaps less listening to to our opponent. And I think this is a time where to listen our opponent very keenly and very intently. As I told you, this exercise also, or perhaps moot court all exercise, will make us people who are more systematic, more logical, and ultimately reducing ourselves to a kind of convincing in our arguments. So hence it invites for a lot of study, a lot of reflection, moreover concentration, which we are lacking these days. My dear students, let me remind you once again, I always do whenever I address the students. We are doing this exercise in this online mode, in this virtual mode. And the temptation for us is to escape, just to have a token attendance somewhere. You can manage to fool us. You can manage to fool the organizer by keeping your perhaps gadget on and not paying attention. Let us remember that it is a loss, and loss once and for all. Nobody else will teach you once you are out of this college. Let us not regret later. And for the first year students, it is a time to familiarize yourself with these legal terms and the method involved in this whole mooting or perhaps moot court exercises. Therefore, I earnestly request you to take this exercise with all its seriousness, with all its intensity, and take active part. There's a lot of constraints in this online mode for such a exercise, but I think we need to make the best use of the available mode for us and make the maximum use of this workshop. My sincere thanks to Mr. Sudeep and Thomas and all the student coordinators who have put on a lot of hard work in organizing this workshop. I'm sure this workshop will go on well, and their hard work will definitely bear fruit. Once again, I wish you all well in this workshop. Wishing you happy learning. I declare this workshop open.
Thank you, sir, for the insightful speech. We'll definitely keep in mind the essential factors involved in mooting. Now, I would like to call upon our principal, Ms. Pauline Priya ma'am. Our principal has always been a source of guidance and support to the Moot Court Society. I request you, ma'am, to shed some light on the benefits of mooting and to formally address the gathering. Ma'am, please.
Thank you very much, Ms. Vijayashree, for that warm welcome. A very good morning to the respected director, faculty, and dear students. I once again welcome you all to this workshop on the basics of mooting. The director has set the tone for today's program. He has made it amply clear that at SJCL, we strive to give you the experience of the real world. And moot courts are definitely an attempt in that direction. Students, if any of you are in the assumption that mooting is an add-on, some sort of an extracurricular activity, then let me make it amply clear for you that all moot courts are a part of the curriculum. It is very much an academic exercise. And therefore, I encourage you all to actively take part in it. The university has made an exclusive allotment of marks for you in the final year. And I recommend that it is best for you to start preparing yourselves for mooting immediately. The Moot Court Society can familiarize you to a moot, but you have to learn how to moot by getting yourself straight into the exercise as soon as you can. As students, I understand that you may have inhibitions, but moot courts are a great opportunity to learn how to overcome these inhibitions. Besides allowing you to engage and understand legal issues, mooting equips you with skills like teamwork, articulation, and many other tools. It's truly an intellectually rewarding exercise for those who are willing to overcome their inhibitions, their awkwardness, and give this exercise a try. I wish you all good luck, and I commend the faculty and the student coordinators of the MCS for this wonderful initiative. I wish you all a wonderful learning experience today. Thank you.
Thank you so much, ma'am. Before we proceed to the instruction and session, I would like to once again welcome each one of you on behalf of the MCS committee. Now, I would like to call Ms. Diksha Garg to give a brief introduction on the session and some instructions.
Good morning to one and all present here, our Director, Father Gerald D'Souza, Principal, Ms. Pauline ma'am, and all the participants and the faculty coordinators who have chosen to join us today. The MCS is extremely thrilled to have been conducting this workshop today. And before we start, I would just like to take a moment to explain the brief structure and the reason behind why we have organized the workshop. Most of this information for students who have been a part of MCS might be a little repetitive, but the reason the workshop is being organized is to familiarize and reorient students with the idea of mooting in itself, to explain the various aspects of mooting. We have divided the workshop into various sessions, being research, drafting, the essentials of mooting, as well as what to do and not do during the oral rounds. Towards the end, we would also have a presentation on the demo moot, just to display what exactly happens during an oral rounds of a moot court and what the students can expect. This workshop is also a means to formally announce the opening of the internal ranking rounds, as well as the AMCC, which is the RK Moot Court competition. Students kindly note that to be eligible to participate and to represent our institution in any of the intercollegiate events, it is extremely important that you qualify these rounds. Without having qualified, you wouldn't be able to get the opportunity to actually moot in these competitions. With this, I also request all the students to just briefly turn on your cameras for a moment, just for us to take a couple of screenshots, and then we will move on towards the workshop formally. Thank you so much, students. If you choose to, you can leave your videos on throughout the workshop, but kindly ensure that you remain muted. Also note that attendance sheets would be circulated by the MCS on the Zoom platform as well as YouTube platform. But the same would be available for a very short duration and we won't be in a position to reopen them. So kindly be vigilant and fill in the forms. I hope you guys have a good and a great learning experience. Thank you.
Thank you, Diksha. Now I'd like to call upon Ms. Joanne and Ms. Simi Sakaria to start the session.
Thank you, Vijayashree. Good morning, everyone. Simi and I will be discussing two important aspects of a moot court competition, which is research and citations and formatting. So a moot court competition is a simulation of a court hearing in which participants analyze a problem, research the relevant law, then prepare the written submissions and present oral arguments. In a moot court competition, there is a requirement of 3 members in a team, or 2, depending on the rules of the moot court competition. 2 persons act as speakers, and the third works as a researcher. Researchers do what their name suggests. They research. Obviously, even speakers have to do it, but the role of the speakers is more important on the D-Day, while the ones who help them to do their best are the researchers, who give them what they need to speak and put forward. However, this should not stop speakers from carrying out their part of research. A lot is said about the skills of oral advocacy when it comes to moot court competitions. But the importance of proper research cannot be overstated. A team must conduct thorough research to ensure that the written pleadings pass the scoring criteria, which is very important, and form a solid base upon which their oral pleadings can be developed. Now, I will be dealing with what goes behind making a memorandum and how do you research for preparing one, which is the most important part of any moot court competition. Now, research never ends, not even on the day of the moot. However, drafting and formatting of a memorial is also very important. Memorial is also called as a memorandum. Now, let's see what exactly goes behind the scenes. Research can be discussed in 3 parts. As you can see, the first one is what are the preliminary steps that you need to take before you start your research. The second is issues. How do you tackle your issues? The third is how to do the main research. Now, moving on to the preliminary steps. Next slide, please. Read your proposition a couple of times until you get hold of the facts. Then I would suggest read it numerous times, because each time you read it, you get a different perspective or you'll get a different fact, and that will always be helpful. Then the second one is draw or make a timeline of events. This will help you understand the relationship between the parties or the sequence of the events. Pay attention to details like dates, places, then the people involved, courts where the petitions are filed, etc. Then note down the provision of law as well as the statutes. Then you need to determine the jurisdiction and the nature of case, whether the case is a PIL or writ like the habeas corpus, mandamus, etc. You need to determine the nature of the case. Then list the provisions of law and statutes. Then the fifth one is to read the Bare Act, which is very, very important. You need to go through your Bare Act. You need to read them very well. And then the last one, you can refer news articles and legal articles. Legal articles written by legal blogs like Bar and Bench, Live Law, Legal India, and many more. I usually use Bar and Bench and Live Law because they give you a detailed perspective of the matter. Then the seventh one is ongoing petitions and cases. For example, there were a number of moot propositions formulated on the basis of Section 377 of IPC. You could refer to those arguments and upgrade the quality of your research work. Now, the next are the issues. You will be lucky if issues are given in your moot proposition, or else just try to restrict yourself to 3 issues. Now, what do you do with the issues? Sit together with your team and brainstorm ideas favorable laws, statutes, or case laws, then divide the issues within yourself, within your team, and the person taking up one issue should be able to do it from either sides, the petitioner side as well as the respondent side. Now set a timeline and try to finish it within that time itself. Even though you've worked on one issue, switch it with your team members and repeat the same. Then the next is, where can you find the material for the main research? Next slide, please. Where can you find the material for the main research? There are 3 places where you can look for it: books, online sources, and the last one are the experts. So for books, there are commentaries, law lexicon, then specific laws, supplementary readings, and so on. And online sources include Google, which is the most important source. You can start your research from Google and then go on to Indian Qanun. Indian Qanun is again a free legal database. You can get the judgments for free from Indian Qanun. Then SCC Online, then Manupatra. Manupatra is an online law database to which our college has subscribed for. We will be discussing how to use it in a while. And the third is the experts. You can reach out to advocates, academicians, or technical experts for help. And that's about the main research. Now moving on to Manupatra. It's a legal database. It has enormous legal material of Indian as well as overseas countries. It covers cases from the Supreme Court, High Court, tribunals, then a lot of Bear Acts, bills, law reports, to name a few. And so when you open the website of Manupatra, the next slide, please. So when you open the website of Manupatra, the landing page is the subscriber's personalized homepage, which you can see right here. You can always click on My Home, which is up there, to come back to this page at any time. Numbers 19, 20, 21, and 24 are really important. So 19 is Manu search. So you can enter your search there. You can click on Manu search. You can enter your search query, and the search engine gives you results based on relevancy. And also, as you can see, the page is divided into 2, the right-hand side and the left-hand side. The left-hand side has the table of content, which lists the database. So if you want to restrict your, if you wish to restrict your search to any of these databases, so if you just need the cases from the Supreme Court, and you can just check the box right there, and the search results will be restricted to only the cases from the Supreme Court. Or if you need any of the ebooks relating to the matter that you have searched for, you can check the box for ebooks there, which is the 4th last. Or if you need bills, drafts, ordinances, you can select accordingly. That is TOC, which is the table of content. And yeah, that's about it. Then the next slide, can you see a red flag in between the green bubble and the calendar, which is on the 2nd issue? So that red flag is the overrule flag. It indicates that the subject case law has been overruled. That is, this judgment is overruled by another judgment. And once you open a judgment, next slide, please. Once you open a judgment, this is how a judgment will appear. On the left-hand side, you can find the Manu citation and the Supreme Court of India before the case, the authority before which the case is filed. Then the petitioners and the respondents are right there. Then the quorum, then the counsels. This is exactly how a judgment looks like. And on the right-hand side, on the top right-hand side, you can find few other icons, which includes, if you want to convert this file to a PDF, you can just click on this, the first one, the initial one. Then if you want to send this to your email, you can click on the mail option. If you want to convert this document into a Word, if you want to do that, and also if you want to look for the commentaries on this particular judgment, you can click on the commentaries. And if you want to save it, and also the order sheet. The order sheet includes all the orders which were passed while the duration of the entire court proceedings. And also the green The green bubble that you can see on top is the authority check or the timeline of authority. The interactive timeline makes it, this makes it easy to pick out the best cases from a large collection of results by displaying in an intuitive graphical format. If you click on that green button, it will open up a pop-up of graphical format, and you can see the number of times the case is cited in other judgments. Next slide, please. Yeah, Manu search will be taken over by Simi. Over to you, Simi.
Thank you, Joanne. So I will be talking about how to use Manu search. So what is Manu search? I hope you can see the option Manu search here on the screen. This is the most basic research that you'll be able to use on Manupatra and one of the easiest ways to find any case law. So you can type your query on the search bar, as you can see over here. And the system is designed in a way that it uses backend algorithm to give you results based on relevancy. The results can be sorted on decision date, title, court name, and relevancy. In order to have Manu search working, we type in our query on the search bar and click Manu search. So we can refine our searches using certain boxes that are given here. You can use a synonym option. However, kindly remember not to use the word or and while you're typing in your query, because this will not lead to perfect searches. Ensure to click the option all documents, then it will directly direct you to all the documents that are available for the given words that you've typed in on the search bar. As Joanne mentioned, you can always refine your search using the that you see on the left-hand side if you're looking in for specific details when you're typing in for your search. As mentioned earlier, this is the easiest way, and if you want to go for specific quote, on the right-hand side, you can see the option for quotes. So you can select which quote you are looking for. If it is a particular high court, then you can give in that quote, or if it's a particular district court or lower court, or even if it is a Supreme Court, you can give in your quote options and you can search accordingly. Giving in your search, there is an option on the right-hand side of the screen that says sort by. So you can sort your search result either by way of relevance, latest case laws, or the newest case law, latest or the oldest ones. So this way you will be able to figure out which judgments are the latest and which judgments are the oldest ones. Over to you, Joanne.
Thank you, Simi. The next is the legal search or the advanced search. So for that, you just need to click on the legal search, which was found, which is number 20, which you could see on the first page, on the home page. And you need to click on legal search, then type in at least 3 letters of the act. So these are the options that you can look for. The first one is the act. The second is the appellant or respondent, judges, case note, subject, subject category, and date, which we'll be discussing in detail. So if you want to search for cases by selecting the act or statute, you just need to type in at least 3 letters of the act. For example, search CRPC for Code of Criminal Procedure. Then select the provision on which the cases are required, that is section or order, or if it's a constitution that you're looking for on which you need the cases, you can select the article. For example, here, it's section 178 of Code of Criminal Procedure. And you may select the database, again on the left-hand side, the TOC. From the TOC, you may select the database, which is optional. And by default, the search is on all documents. And then just click on search. You have an option to search 2 acts in combination by clicking on add more across the act text box. Another box will appear where you can type or choose the second act to search combination with the first act. This feature is very important at times. At times, provisions of 2 acts are referred in conjunction to each other in a case. So type at least 3 letters of the second act. For example, search for Negotiable Instruments Act, and you can select the provision just like how you did before in the former act. You can select the section or order or article depending on the act or the provision. And you may select the database from the left-hand side and then just click on search. And also searching, the second is searching for cases by the appellant or the respondent's name. To search for a case by appellant or respondent name, if you know someone, if you know the name of the appellant or the respondent, you can just key in the words and then find it. Okay, you can find it. You just need to type unique appellant or respondent's name. For example, you can just search Konkan Railway, and all the matters related to Konkan Railways will be displayed as a results. And again, it's optional for you to select the database, and you just need to click on search. And when you do it, you need to avoid common words such as Mr., Miss, Mrs., Doctor, Limited, or Ward. And also you need to avoid words that may be abbreviated, like company or limited, LTD for limited. And just click on search. Then searching for cases by the judge's name. If you need the cases of a particular court, you can just type the judge's name or type 3 characters of the name, and you will get a list out of which you need to select the name from the drop-down menu and then click on search. Then the next option that you'll be having will be case note, searching for cases by case note. Case note search allows you to restrict your search only to the case note of a judgment instead of a full text of judgment. This search is restricted to those judgments which have case notes. Not all the cases have case notes. So that's how case notes work. And the next one is searching for cases by
Joanne,
yeah.
the PPT is not visible. Just give us like 2 seconds.
Yeah, sure. Thank you, Simi. Coming back again. You can also search for cases by subject or the subsubject. You can find the same below, case notes, and you just need to choose the subject from the drop-down box. For example, arbitration, and then type in subsubject. For example, appointment of arbitrator under the main subject, which is arbitration. And you can also select the database again to search or search in all documents. Then just click on search. It is not mandatory to type a subsubject. And then the next one is searching for cases by subject category. Subject category is a categorization given by the Supreme Court to the judgments pronounced. Supreme Court has lately started categorizing its judgments in subject categories. All judgments which are categorized under subject category have been updated in our system, in the Manupatra system. Around 11,000 cases have been categorized by the Supreme Court, and the subject category field can be used individually or in combination with the legal search fields. Search on this field will be restricted to judgments which have this field. Not all the cases have been categorized. It's only those certain cases which will be available. And and the last one is searching for cases by date, which to search for cases on a particular date or period, you can select a date option. It can be before, on, after, range, and last. So if you click on the drop-down menu, you will get all these options, which is before, on, after, range, and last. You'll be able to see it once you start using it. And you can select the date from the calendar, and you may select the database, which again is optional, and then click on search. You can also search on a particular range or a period by selecting the range option. You can search judgments for the last specified number of days or weeks by selecting the last option and making selection from the drop down. And also, if you can see on the right hand side, there is a option of miscellaneous searches. The next slide, please. So if you can find on the right hand side, it's the miscellaneous searches. On the right, you will view the miscellaneous searches, the case laws by selecting bench, judgments under act or statute. Then the last is the case law search by case number. These are the three options which comes under miscellaneous searches. The next slide, searching for case laws by selecting bench. This allows you to search for judgments pronounced by selecting the bench. And before, you could search for cases when you key in the name of the judge. But here you can just select the bench, which is single bench or division bench and full bench. Again, the name of the judge is optional. If you want, if you know the column, you can enter it and you can submit, and the search results will be available to you. You need to select the bench from the drop-down menu, then select the subject from the drop-down menu, then select the court name and the type the name of the judge in the judge field, which again is optional. It is helpful if you're looking for the judgments by a specific judge, then click on search. Then the next one is searching for judgments under their act or statute. This allows you to view all cases, all such case laws that have reference to statutory provision of statutes or acts. You can select the act from the options given, then type the initial 3 characters of the act you wish to look for case laws under, then select the act from the drop-down menu, as you can see there, then select the statutory provision under which you wish to view the case laws, and then just click on search. And that's about judgments under act or statute. Then the next one is searching for case laws by case number. That is, you can just click on case law search by case number, and the click will take the user to the following options. So as you can see, select the code, enter the case number, and you can find a particular desired format by the Manupatra, and you need to enter the case number in that format, and then select the code from the drop down under select code, then enter the case number in the text box under. Then you can select all that, you can fill all the boxes, and then you can click on search. There may be multiple results against the case number entered, and the user can identify the case which he is looking for. And yes, over to you, Simi. Simi will be doing the rest. Thank you.
Thank you, Joanne. Coming to citation search. So what is a citation? Citation is a reference to a specific legal source in order to identify legal cases. Every case decided by all the courts has a number assigned to it to make it easier to identify them and cite them according to our requirement. Every case has a publisher, year, volume number, page number, and the court it was decided on. So how to go about citation search? As you can see on the screen, first and foremost is that we can either select it's an Indian citation that we're looking for or an international citation that we're looking for. If it is an Indian, there are various publishers which will be shown to you later. If it is international, again, there are various other publishers which will again be shown to you later. So first, going on to citation search. If you're looking for Indian cases, you can select the bullet point for Indian citation. If you're looking for international cases, you can select the bullet point international citation. Then the next is publisher. Select the publisher from the drop-down menu that's provided. For example, over here it's written AIR. AIR stands for All India Reporter. Similarly, we have various other publishers like SCC, which will be shown to you a little later so that you get a clarity on what publishers are. After that, you go for the year. So enter the year or select in the drop-down menu. So what happens in the engine is that the system is designed. So when you put in or key in your publisher, the year, volume number, page number, all will be given in the drop-down. Accordingly, you can select it. So every case has a year. Every case will be decided on a particular year. So you key in your particular year. Then comes the volume number. If you're aware of your volume number, given your volume number along with your page number. So every case is decided in a particular code. So given this, you can select in the code. When you drop the option down, if you've given in all your correct details, the code normally automatically appears there. If not, you can always go and select your particular code that you're looking for and go on for click it, and you can key in and you can search in and you can get your results thereby. So this is how the page will look like once you click search. So on the left hand side, you can see the Manu citation. In the middle, you can see publisher citation, and then on the right hand side, you can see judgment title. So when you key in your publishing details or your case citations correctly, it will find out the cases that you're looking for and give it to you in an option, as you can see on the screen. As I earlier mentioned, there are various publishers in India as well as international publishers. Some of the publishers are given on the screen. However, there are so many, but some of them are accident and compensation cases, SC, accident claims journal, All India High Court cases, All India Prevention of Food Adulteration journal, All India Reporter, which we saw earlier, All India Reporter with volume, All India Reports, Bombay High Court reports, All India Reports, Karan Diwani reports, All India Reports, Jharkhand High Court reports, All India Reports, Karnataka High Court reports, and All Maharashtra Law Reporter. So these are some of the cases, some of the publishers that we have in India. Some of the international publishers can be seen on the screen. All England Law Reports, Appellate Division cases, Bangladesh Legal Decisions, Corporate Law Decision, Dhaka Law Reports, Appellate Division, England and Wales Case Law, and likewise, as you can see on the screen. So coming to the next part of our presentation, we have to focus on drafting the memorandum. So every memorandum of a conventional note is designed on a particular format, and it never changes. So the contents of a memorial are given on the screen: cover page, table of contents, table of abbreviations, index of authorities, statement of jurisdiction, statement of facts, issues raised, summary of arguments, arguments advanced, and prayer. Then we have statement of jurisdiction, the provision of law under which the case has been filed or preferred, of issues and arguments. Kindly note that I am not going to explain further on these. There is a drafting session that's coming up, which will be taken up by one of the moot court members, who will explain in detail how to draft a memorandum. Coming to citation and footnotes. Perhaps one of the most important skill that any and every researcher should have while going for a moot court proposition. Always ensure to read the rules and regulations of the moot court proposition, since all the rules pertaining to the competition will be enclosed within the rules and regulation. Always keep an eye out for the form of citation that is required. There are different types of citation, being Blue Book, the standard one, OSLA, the Oxford Standard for the citation of legal authorities, and then we have SILC, which is Standard Indian Legal Citation. The format of citation or footnotes will secure you a lot of marks. The skill of a researcher is heavily measured on their formatting skills and technique. I cannot specify further on the requirement to read the rules and regulations carefully. Because if the rule is required, the rule is asking you to go for Blue Book and you follow SILC, that will cost you a lot of marks. So always keep an eye out for the rules and regulations, read it properly, understand what the rules and regulations is asking you to go ahead with. For example, you can see here, we have taken two cases over here, Navtesh Singh Johar versus Union of India. As I mentioned earlier, every court where a case has been decided on will have a number to make it easier for us and lawyers or anyone that is searching for a case. So you can see some numbers assigned to the case. So the number that is enclosed within the parenthesis is 2018. It's the year that the case was decided on. 10 denotes the page number. SCC is Supreme Court cases, one of the databases where the case is available. And then 1 denotes the volume number. Then we come to Keshananda Bharati versus State of Kerala. Over here, we have again a number or the citation that is assigned to the case. So which is AIR, the publisher that we saw, All India Reports. 1973, that the year that the case was decided on. SC denoting Supreme Court, the case of the court that the case was decided on. And then we have 1461, that is a beginning page number of the case in the journal or in the report. Then we go on to formatting. Always remember to justify your content. It is highly important to justify your content, except for the headings, which can be center aligned. Everything else must be justified. It will be very beneficial to pick up on a few shortcuts on Word, as this will save you lots of time. For example, we have Control+J, Control-E, Control-J for justification, and Control-E for center alignment. Then Control-B, Control-I, Control-U. These are basic shortcuts of Word for making the content bold or underline the content. Control+Shift+K gives you small caps immediately. You don't have to go and format it manually. Control+P will give you a page view of the particular page that you're on, so that this way you can see how the page would look like in its entirety. So check for the font size and font style, line spacing, and spacing after paragraph. If you're applying space after a paragraph, ensure to keep the pattern throughout. Do not keep changing the spacing through the content. Ensure to follow a particular pattern. A person who has researched or worked on documents or a memorial or moot court propositions can easily pick out or identify if there are any discrepancies. It's so identifiable. So if you're following a particular pattern, follow the same throughout your entire memorial. As a researcher, when you're searching for certain cases or documents, you might come across a situation where you won't find the format on how to cite a certain document. However, that's all right. In such a case, remember to maintain uniformity. This will be a treat to the eyes when there is a formal pattern and uniformity. If you can't find a citation format to probably cite a press release or a news or a video or anything, ensure, if you're following Blue Book, ensure to follow the particular pattern that you've used above. It is very identifiable and it stands out, not in a good way, if you mess up the uniformity, because that will cost you a lot of marks. Ensure that you number the paragraphs and the numbers are continuous. Often what happens is that we remember to format the entire content and accidentally leave out the numbers. For example, while we select the entire content, either by using Control-A or by content, you can notice that are automatically put in don't get selected. So what happens is that the content is in one font size or font format and the numbers stay in your default format. And this is very easily noticeable when you take a look at it just once. So when we select the entire content, to change the pattern or change the format, ensure to select the numbers afterwards to secure you a lot of marks. Number your pages either at the top or at the bottom. This will help the person reviewing your memorial. You can always use any software to check your grammar. This will save you lots of time if you're doing it online, so that you don't have to spend a lot of time doing it. There are free online sites and software available like Grammarly, which will check the grammar of the content. For some moot court competitions, there is a required percentage for plagiarism. There are many sites available which will check the plagiarism of your memorial and ensure to keep it within the allowed percentage. And do not capitalize words unnecessarily. I cannot further specify on the fact to maintain uniformity throughout your entire content. Do not capitalize words unnecessarily. Do not make them bold unnecessarily. If you're following a certain pattern for the headings, whereby you make it bold, make sure all the headings are bold. Do not make one bold and do not make another underlined. Do not italize another one. So this way, there will be no uniformity throughout the content of your memorial, and this will look odd to the person reviewing your memorial. Make it formal, make it justify your content. This way, it will be a treat to the one who is reviewing your memorial and will secure you a lot of marks. Thank you.
Thank you, Joe and Simi. Now we'll move on to the Q&A session. Those who have any questions pertaining to this session, either raise your hands, you can put it up in the chat box and we'll address them one by one. Yes,
Yeah, hello, ma'am. A very good morning, ma'am. Yeah, ma'am, could you please show us the slides on the legal search of the Manupatra, because the slides didn't start working from there and we kind of missed it.
I think we have one more question in the chat box. Can anyone access the mentioned sites like Manupatra, or will we be given credentials to access it? You can raise your hands, you can talk. Those who have raised your hands, and to answer this question, no, not everyone can access the mentioned sites. Our college has subscribed to this particular legal database, and the credentials will be shared to you shortly. And there is also Indian Kanun, which is of easy access. You don't need any credentials or anything. You can get the basic judgments and everything there. Yeah, Soeb or Rajay? Yes, Soeb.
Good morning. Hi, Joanne. Could we just go over the volume number point once more? If that's okay. I kind of I feel like I didn't understand that point. I think it was under citation search, if I'm not mistaken.
Surely. Can you just specify your question? Repeat your question again. Which bit?
Oh yeah. I wasn't clear as to what the volume number search meant under the citation search, like part of this presentation.
All right. So This PPT will be shared to you. So like I mentioned, every case that is decided by any court has a number assigned to it to make it easier for us to identify them. So if you can, yes, so I'll show you, for example, rather than citation search, I will show you this case. Yeah. So do you see on the slide that we have a particular citation that is 2018-10 SEC 1. That is a citation that is assigned to the case titled Navteej Singh Johar versus Union of India.
Yes.
So 2018 is the year the case was decided on. 10 is the volume number. SEC is the database, Supreme Court cases, and 10 is the page number and 1 is the volume number. So it's a journal. It's a huge report. Every year the journal keeps changing, or the report, there is a report for every year. So if one volume is completely full, they go to the next volume. So volume number 1, so they will be 10, 20, 100, depending upon the number of cases that's decided in a particular year. Page number, if you go to the library, our library has various reports, various journals over there. You take a journal, you go on to a specific page, you find a case. So for example, if you take for Keshananda Bharati case, if you take the All India report, go to page number 1461, you can find Keshananda Bharati case on that page. So to make it easier for us to identify the case, every case has a citation assigned to it. So this is nothing but it's like a name that is assigned to us, or a page going by a particular title. This is nothing but citation is a legal reference to the case that has been decided. I hope that makes it clear.
Yes, it does. Crystal clear. Thank you so much.
You're welcome.
Yes, so this was regarding the competition itself. So like I had read the instructions. So it said that we will have our first round, after which they mentioned that we'll have a draw of lots again. So will there be 2 rounds for the competition for IRR?
Hi, Ajay. Thank you for that question. With regards to the number of rounds, etc., you will get more clarity. First year students, don't get confused. This is not with regards to AMCC. This is in regards to the internal ranking rounds, which is specifically for the seniors. The number of rounds, etc., will be clarified to you. But essentially, the reason draw lots has been mentioned is because you will be allocated a site before the day of your oral rounds. That will be happening on the 17th. So even in a situation where you only have a single round, you will still have a draw lots, because you have to submit the memorandums for both sides, and then you will be allotted one side on the basis of the draw lots. I hope that's clear. All right, cool.
Before we proceed to the next question, there's a question on the YouTube chat box, and it says, can you please guide if Manipura has a list of ongoing cases too, or is it a repository of decided cases alone?
Yes, surely. Some ongoing cases are there. So in any ongoing case, there are certain orders or decrees that are decided by the judge. So in such a case, you can find certain orders. So if a case is not entirely decided, like the final judgment is not out yet, the order that was given during the process of the case will be available on Manupatra. And when the final judgment is given, that will be there. Even if the case goes for an appeal later on, whenever it will be available. But certain times only some ongoing cases can be found, not all of them.
Hi, am I audible?
Yes.
I wanted to know, in the last slide, they have, it was mentioned the control keys, the control J and the control E. So where is that? Is it used in the Manupatra website or where? I just wanted to know that.
Thank you for that question. So those shortcuts were for Word document. So when you use Word on any device, it's different for Apple, iOS, or MacBook. But however, on Word, you will be able to find a lot of shortcuts. For example, Control A will select the entire content. Control C will copy your content. Control V will paste your content. So these ways, there are so many shortcuts. So I was just specifying the shortcuts that you can pick as a speaker, but mainly as a researcher for you to save a lot of time when you're working on your memorial. So there's a question asking us to show us how the legal search works because the slide stopped working. I hope you were able to hear the parts, but kindly remember that we will be sharing these slides. So it's properly explained in the slide. You can just go through. So once the session is done, we'll be sharing all our PPTs for your convenience. I hope that answers your question. If after that you still have queries, you can always reach out to MCS personally or on the group. We'll be able to address your questions or queries.
I can also give you a brief. Do you want the PPTs to be shown as well? Okay, thank you. Thank you, Simi. So for the legal search, it's the advanced search. For Manu search, you just have to key in the keywords. You just need to type in the keywords, and you'll get all the results based on the words that you have typed in. But for advanced search or the legal search, you can search for cases by selecting or choosing any of these options which is visible before you. That is Act or statutes. If you want cases relating to Code of Criminal Procedure Section 178 or any other provision of law, you can select that. You can just select the search button. And if you want to search for cases by the appellant or the respondent's name, if you know the appellant's and the respondent's name, and if you want to just go with it, you can do the same here. And you can also do the same procedure in the Manu search also. Manu search is more like Google, and legal search or the advanced search is a bit more complicated. And if you know the name of the judges, the quorum, you can type it and you'll get a drop-down menu and you can select the name of the judge from there. And the case note is where not all the judgments have case notes. Only few of them have case note, which is a brief of the entire judgment. So if there is a case, if there is a judgment which has a case note, you can find it there. You just need to click on search. And also if you need to select a particular subject, for example, I said arbitration, you can just write arbitration. You can just select the subject from there. And if you have a sub-subject, example which I said was arbitration, appointment of arbitrators under arbitration, you can select the same under the sub-subject, which is again not compulsory, and you just need to click on search. And also subject category. Subject category is something that the Supreme Court has categorized the entire cases into. Not all cases come under subject category. It again is a recent development by the Supreme Court. You can read more about it on online somewhere. And the last one is date. Before, on, after, range, and last, as you can find below. You can click on that and you can find the range or you can find the date from the calendar and then just click on search, and all the cases which were pronounced on that day or before that day, depending on what you have chosen, will display before you. And on the right hand side, you can find the miscellaneous searches. And if you want to search for case laws by selecting the bench, depending on whether it's a single bench or division bench or full bench, you can select the same from there. And also there is an option to select the name of the judges and the subject matter, again, which is optional. You can find the same from there and you can just click on submit and you'll get all the results. And the next one again is searching for case laws by Can you come to the next slide, please? Yeah. Searching for case laws under a particular act or statute, you just need to select the particular statute from which you need the cases for, and then just type in the act's name or the provision, and then just click on search. That's just about it. And also the last one is to search the case. Next slide, please. Using the case number. So you know that all cases have case numbers, right? So you just need to enter the case number in the prescribed format. So for example, 20/2010, as you can see there in the second option, you need to select the court, enter the case number, then select the date of the decision, which is again optional, and then just click on search, and you'll get the results like that. Is it clear? Someone who asked the question, is it clear to you? Okay, thank you.
Thank you, Joe and Simi. Everyone, please note that we'll be posting the Google form for the attendance. The Google form attendance will mark the attendance for the first and second hour, and it shall be open only for a maximum of 5 minutes. Please ensure that you fill those forms for your attendance purpose. And any other question pertaining to this session will be addressed in the next session. And we shall be meeting again at 10:20. The session will start at 10:30, but everyone is requested to join at 10:20. I hope that's clear. All right, so this is the end for today's session, for the first session. We extend our gratitude to our respected director and principal for bestowing us with their presence. We also extend our gratitude to our faculty coordinators for their guidance. We hope you had a first enriching session. Thank you all for joining us. If there are other questions, we'll be dealing with them in the next session. Thank you for your participation and patience. We'll see you in the next hour.
Hello guys. So we will be posting another form. This is the attendance sheet for the 10 to 11 hour. Kindly fill it in. The form for 11 to 12 will be shared at the end of this session. To the students who've just joined in, kindly see that there is the link for the second hour which has been posted on the chat box. Please fill it in. We will be closing the link by 10:26.
Everyone who's joined the meeting just now, please note that there's a Google Form link that has been keyed in your chat. Please fill it because it closes at 10:30. This is for the hour between 10 to 11, so please fill in right now. Good morning, guys. So I hope all of you had a nice session and a nice time listening to Simi and Joe. Another essential step in a moot process is, after research, of course, is drafting. As a mooter myself, I give immense importance to drafting and the way my arguments are written, because that's the first thing that the judge observes before listening to our oral arguments. So to elaborate on the fundamentals of drafting, we have with us Rishabh Jain, who will walk you through the most important components of drafting. At this point, it will be important for you to note that there is no one way of drafting. Drafting is creative. There'll be certain rules in which you can draft, but there is no real one method or so in drafting. On that note, I invite Rishabh Jain to take up.
Give me a minute. Is my screen visible, guys?
Yes, Rishabh, you can proceed.
So, good morning, everyone. Before I start the session, I would like to share my personal experience when it comes to memorandum drafting. So when the first time when the moot competition was introduced to us for the internal ranking and everything, we were not, though the college had given us enough sessions and everything, but I myself was not confident enough for memorandum drafting. I was a little scared when it came to drafting. And because of that fear itself, I didn't really take part in any of the competitions in that year. And that was quite a setback in that year. But once you start working in it, and once you start reading upon it, it's not really difficult to crack it, and it's not really difficult to draft a memorandum. So let's go ahead with it. So let's start with what exactly do you mean by a memorandum? So every moot competition has two aspects to it. One, written submission, and other one is the oral submission. The written part of the submission is known as the memorandum or a memorial. Like how a moot court is how moot court competition is a simulation of a courtroom scenario. A memorandum is essentially a petition that a lawyer submits before a court. In every moot court competition, the memorandum and the contents of the memorandum and the formatting and everything carries a huge weight towards the final score of your team. It can take you to the finals and everything, and it can lead to your disqualification as well. So what are the essential ingredients of a memorandum, or how exactly do you structure your memorandum? So let's break down the essential ingredients of a memo. Generally, a memorandum has 10 basic ingredients in it. The first one is cover page. The next one is the table of contents, then the index of authorities, index of abbreviation, statement of jurisdiction, statement of facts, statement of issues, summary of arguments, arguments advanced, and it ends with the prayer. It may seem like a lot, but it's not really difficult. And once you have a grasp over the basic aspects of these elements, you can easily draft one. So let's break down each element individually now. The first thing that comes is the cover page. The cover page is the first page of the memorandum. It is essentially the introduction to it. Now, the cover page contains certain essential ingredients, such as the name of the competition, that is the name of the competition where the memorandum is being submitted, or where the competition where you guys are taking part. And next is the name of the forum. It refers to the court or the authority where or before whom you are submitting the memorandum, or where the case has been listed. Next comes the name of the case. That is the name given in the moot problem itself, that is the petitioner versus the defendant. Next is the title of the memorandum. It points out by whom the petition has been filed, whether the memorial has been filed on behalf of the petitioner or the defendant. Next comes the team code. Now, in any competition, moot court competition, you're not allowed to declare any of your personal information, be it your name or your college information. The organizing committee assigns each and every team a particular team code, and that team code is the identity of your team throughout that competition. And in the cover page itself, you have to mention your team code. Now, the final thing is the front page of the memorandum is either red in color or blue in color. The red represents that the memorandum has been submitted on behalf of the respondents, and whereas the Blue shows that the memorandum has been submitted on behalf of the petitioner. Over here, I have a sample from one of the previous moot competitions. It's a sample of how exactly a cover page looks like. As you can see on the top, there's the name of the competition, that is University Law College 25th All India Moot Court Competition. Then is the forum where the memorandum has been submitted. In this case is the Supreme Court of Jimland. Then comes the name of the case, that is Zarina and Cersei versus Zimland. This could have been a perfect cover page. However, there are certain elements that are missing over here. Can anyone point it out? Anyone from the audience can point out what exactly is missing from this cover page that would have made it an ideal first page?
Guys, we expect you to interact, so please raise your hand or key in the chat box.
Thank you, Ma'am. Yeah, go ahead. I think someone raised their hand.
I think Angela raised her hand.
Yeah.
Yeah, you can go ahead answering. Okay, someone says team code.
Yeah, that's one element that is missing over here. Generally, on the top right corner, you mention your team code. There's one more element that's missing over here.
Okay, if some of you are struggling to unmute, so you can just key in your chat box. So we'll look into the message.
So if no one is able to point it out, yeah, exactly. The title of the case is missing. That is whether the memorandum has been submitted on behalf of the petitioner or the respondent. This was a sample taken from a respondent memo, and ideally it should have the case with the memorial has been submitted on behalf of the defendant or plaintiff should have been written over there. So these are the two essential ingredients that were missing from this. So next ingredient that comes is the table of contents. So it is an index of the entire memorandum. It lists out the sequence in which each chapter appears and the respective page numbers. Over here, you can divide your important chapters into sub-ingredients or sub-chapters and show their respective page number and indexes. The table of contents is necessary because it not only gives you the entire structure of a memorandum at glance, but also enables the speaker or judge or any other person who's going through a memorandum to locate any relevant material or any relevant source. So I'll show you two samples now of what a table of content can look like. Can anyone figure out which sample is correct and efficient and which sample is not? This is the first sample. This has been taken from one of the memorandums that was submitted. And this is the second sample. Can anyone from the audience figure out which sample is correct and which sample is not, or which sample is not that efficient? You can either raise your hand or you can key in your response in the chat box. Okay, so many of you are going with sample one. Is it, you guys think sample one is correct? Okay. So there are lots of mixed responses. So see, in sample number one, the drafters have divided their statement of facts into 6 parts, which is not really essential and which is not really required when you draft a table of contents. You don't have to show your statement of facts divided into sub-ingredients. However, one essential thing that you could have, that the drafters could have done at that point was they could have divided their summary of arguments into sub-points. Yeah, in this sample, the sample number 2, we can see in the arguments advanced, the drafters have divided their sub-issues into issue number 1.1, 1.2, and so on. And they have keyed in which page number it starts from and which page number the next one starts from. So when you're, so this becomes very efficient and very easy to locate your arguments. And while you are in your oral rounds, you can refer to your, you can ask the judge, like when judges ask, you can ask them to refer to a certain page like that. And whereas over here, the statement of facts, not necessary to subdivide it and show it on your table of contents. Next comes the index of authority. So index of authority refers to all the legal sources, legislations, and any such materials that has been mentioned or referred to in a memorial in a particular memorial. In a memorandum, it is very essential to list out in a categorical manner all the authorities, all the case laws, all the precedents, or anything that you're using as a source to back your arguments. Essentially, there are 4 basic authorities that you can point out. Now, first is statutes, next are the websites, third is the case law, and last is commentaries and books. Can anyone from the audience define what exactly statutes stand for? Can anyone define what exactly statutes stand for? Yeah, you can go ahead.
Hi, good morning. Am I audible?
Yeah, you're audible.
Yeah, so statutes would be like the statutory law, as in like the law from the Bare Acts, if I'm not mistaken.
Yeah, basically the laws passed by the legislative bodies, whether at the center of the state.
Yeah, my bad.
That's correct. Thank you so much. The next are the websites. While searching or while researching upon your case, you're going to refer to a lot of websites such as Manupatra, such as India Kanoon, or such as SSC Online, or you're going to refer to various journal sites. So you have to list out all your websites that you have used, and you have to list them in a categorical manner. Next are the case laws. Can anyone again define what exactly do you mean by case laws, or what does it stand for? Yeah, go ahead. Yeah.
Well, I'm sorry, I had my hand raised from earlier. I'm really sorry.
Does anyone would like to try? Anyone from the first year would like to try what exactly a case law means?
I think there are 2 hands raised, Rishabh.
I couldn't see that.
Am I audible?
Yeah, I'm audible.
Kavya and there's Rama Session. So we can have Kavya go first and then Ram. Yes, you are audible. Kavya, you can go ahead. Are you able to unmute? Okay, so since you're not able to unmute, we can just go.
Can you hear me?
Yeah, I can.
Okay, so case laws are basically the laws that are based on the case that have already happened, the precedent cases.
Yeah, essentially correct. And yeah, many people have actually really keyed in the chat box as well. Yeah, case laws generally refers to the legal precedents and the decided cases from various judicial authorities. Next are the commentaries or the books. It refers to the various books, journals, articles, etc., written by various scholars or publishers such as AIR or SSC. You have to list them out in and your index of authorities, and you have to list each and every case. I'll show you a sample. So this is a sample of what index of authority looks like. Over here, you can see that the drafters have given the case title, the citation, and the page number where exactly it has been cited as well. The one thing to note over here is the case have been listed out in alphabetical order, as in they have categorized it in alphabetical order. They have referred the citation as well as the page number as well. It again becomes, this is very, it's very good, or it's a good thing to do, because when it comes to the oral round, it's going to be very handy for you guys. Over here, you can see the way the drafters have listed out the statutes, the treaties, dictionaries, books, and everything. One thing to note over here is while citing either dictionary or books or commentaries, you have to mention the author's name, the book name, the publisher's name, the edition, and the year in which it was published. You have to mention all these things while of that particular book which you have referred, while mentioning that in the index of authorities. Next is table of abbreviations. Now, table of abbreviation contains all the a list of all the short forms that you have used in your memorandum. It contains the symbol and what exactly it stands for. Now, you can either use the pre-established abbreviations such as VS or V dot for versus, or AIR for All India Reporters, or you can make your own abbreviations such as COI for Constitution of India or CJ for Chief Justice. All the memorandums have to, generally all the memorandums have to adhere to a certain page limit, and use of abbreviations for certain repetitive terms or certain long terms can save you space, which you can further utilize for your arguments. Now, important thing to note over here is that you need to maintain uniformity throughout the document. You cannot use VS for verses at one point and V for verses at another point. You have to be constant with your abbreviations. Here's a sample of what an index of abbreviation looks like. Over here, you can see that on the left-hand side, the drafters have given the symbols, and on the right-hand side, they have listed out the expansions. Over here as well, the drafters have categorized it in alphabetical order. Next comes the statement of jurisdiction. Now, statement of jurisdiction is a very important part of a memorandum. This chapter essentially proclaims the jurisdiction of the court where the petition has been filed. This part is very important, very essential, because this statement of jurisdiction either maintains your case or it does not, is not maintainable, whether it proves your case is maintainable in that particular court or is not. If your memo is like, if your statement of jurisdiction is wrong or if there is any error in it, then it doesn't matter what exactly you have written after this, because if you have not, you're not able to maintain your case in a particular court, it won't really matter what exactly you have written in a memorandum. So statement of jurisdiction is very essential and you have to get it right. Over here, here's a sample of what a statement of jurisdiction looks like. As you can see, they have clearly pointed out that the fundamental rights of the petitioner are being violated, and hence under the relevant provisions of the constitution of that particular country, they're approaching the Supreme Court of the country, and they have listed it out. And also in the citations, they have listed out the relevant provisions of the constitution. Now comes the statement of facts. Now, statement of facts is the summary of all the relevant facts that have transpired before the filing of the case. It contains all the necessary events that are important. Statement of facts are descriptive in nature, and it generally maintains a neutral tone. That means while you are drafting statement of facts for petitioner, you cannot state facts which are kind of in favor of petitioner and not you are hiding or you are not giving facts for the defendant, or vice versa. The statement of facts can be filed in various formats, such as in paragraph and pointers, in timeline format and subdivision. It totally depends from team to team, the way they prefer and their formatting style. I'll show you a sample of each one right now. So this is sample number 1. Over here, we can see that the statement, the entire facts of the case have been divided into subtopics, and under each subtopic, a description of the event has been given. Next is the statement of, in this form of statement of fact, they have listed out the entire statement of fact in pointers or paragraph manner. And finally over in this, finally in this sample, we can see that they have given a general introduction on the top, and then they have given a particular exact timeline of how exactly the events went on. In a chronological order, they have listed out each and every fact that have happened. Next is statement of issues. Next, this chapter dictates the question of law that are in consideration in the given moot court competition. It is a short legal statement or legal issue that is involved in the case. It dictates the judge about what exactly the party or the speaker wants the court to decide. These statements are very short, to the point, and always ends with a question mark. Generally, in most of the moot court competitions, the drafters or the competition organizers give the questions of law involved in the problem itself, and they also provide a provision that if the participants feel there are more legal issues involved, they can draft their own legal issues. This is a sample of this is sample one for how exactly a statement of issues look like. Over here, you can see that there are 4 issues involved. They are very short, to the point, and they are ending with a question mark. This is another sample of from a different memorandum. Over here, again, short, to the point, and it's in the format of a question, not in the format of a statement. Now, summary of arguments. This is the next chapter, or the next essential ingredient in the memorandum. Summary of arguments is the short introduction to the arguments advanced. Over here, you need to give the summary of your arguments for each and every issue that you have raised in the previous chapter. They are generally short and does not exceed 4 to 5 lines or 1 para. Over here, you need to point out yours under each issue. You need to point out your stand exactly. Like under each question, you need to point out either you are for that, either you are affirmative or negative in that particular question of law, or on that particular issue. And also, in brief, you need to mention why exactly, what exactly is the logic behind your stand. So I'll show you 2 samples again about how exactly a summary of arguments looks like. Over here, you can see that about the 4 questions that were raised, the drafters have pointed out their stand under each question of law, and they have given not more than 4 to 5 lines under each each question of law. This is another example of summary of arguments. Same format, you can see 4 to 5 lines and short to the point. Now comes the most important part of the memorandum, is the arguments advance. It is the core element of your memorandum. It can be called the heart or the soul of your memo, of the entire document. The quality of your argument advance, the type of arguments, the structure of your arguments would directly reflect the amount of research done by the participants. Over here, the drafter needs to explain each issue in depth. They have to show, they have to point out their stand on particular issue, the logical and the reasoning, logical and the legal reasoning behind their stand, the authorities that they're using to back their stand, and the reason, and the conclusion that they have arrived. For this purpose, you can rely on various authorities that we have already discussed, such as case laws, the enactments, commentaries, etc., for your legal backing. In order to make your arguments advance a little more structured, a little more easier to comprehend and draft, what you can do is you can divide your arguments or issue of law into various subparts, and you can, under each subpart, you try and you give the answer to it. You give an introduction, you give your reasoning behind it, and you give a conclusion. And once you have answered each and every subpoint, your main issue itself would be solved. This can be done for all the issues in of all the issues given over here. So this is a sample for arguments advance. Over here on the left hand side, you can see that the issue number 2 stands whether right to life includes right to get married to any person belonging to any religion or sex. Since it was a respondent's memo and they stand negatively on this point, in the introduction para, they have given that no, the right to life does not include the right to get married to any person belonging to sex and religion. And in order to prove this point, they have divided their entire issue into 2 parts. The first part tries to prove that the right to marry is not exclusively a part of Article 21. And the second part states that the court cannot declare the rights when none exist. On the right hand side, we can see that once they have once they are done with each subpoint, they have given a conclusion to the entire issue itself. Next, one second. Next is the prayer. This is the final chapter in your memorandum. It indicates the exact relief that the parties are seeking from the court. It should not be elaborate and it should be crisp and again to the point, because you need to ask what exactly, you need to give in a limited numbers of this thing, that what exactly you want the court to decide. Since you either ask the court to do something or not to do something on your behalf, generally action words are used in your prayer. Now I'll show you 2 to 3 samples about how exactly a prayer looks like. So this is sample number 1. You can have a look at it. This is sample number 2. And this is sample number 3. These all prayers have been taken from various memorandums which have qualified for best memorandums in various competitions. So this is a ideal format for your prayers as well. Now, with the prayer, we come to an end of all the essential ingredients for my memorandum. Those 10 ingredients are essential ingredients, but one essential ingredient or one very important aspect that people generally don't look into depth is formatting. Formatting of your document plays very important role in your final score or in your score for a memorandum. Generally in a memorandum, generally the formatting of a memorandum, the rules regarding it are given by the organizer. The font size, the font, the line spacing, the alignment, everything has been given in the rule book. So make sure that you go through the rule book and you follow the same formatting method. Apart from that, what you can do is you can add things like name of the competition, the title of the memorandum, the page number, etc. in the header or the footer of the document. Things like line spacing, font alignment, etc. doesn't really catch your eye, catches your eye in the first glance. So you need to make sure that you go through your document, scrutinize it very properly. And it does take quite a good amount of time. So I would advise you to at least reserve 1 or 2 days for going through your document, formatting it properly, because you may, if even if there is a minute or there's a spacing error or there's a line spacing error, you may end up losing marks. And with that, we come to end of this session.
Okay, guys, so now you can ask questions on whatever he has presented. Just keep it to whatever he has presented and not beyond that. You can also ask questions from the previous session if you have any. Key in your questions in the chat box and we'll take it one by one. Rishabh, so there's one question by Selva Mary which says, how many pages should a memorandum contain?
The structure regarding the number of pages under each and every chapter or the number of pages that you can go for is generally given in the rule book, and they only tell you that the maximum number of pages that you can use for state arguments advance is suppose 20, 25 or like that.
Yes, so Rishabh, will you be able to take a question on citation? The question says, is there a difference between SILC and Blue Book citation, or is there any specific format, because it wasn't explained apparently for Blue Book? Okay, so I think I can take that question. So yes, each citation format is separate. Okay, I think Simi will be in a better position to respond. So yes, Simi, you can take up this question.
Yes, thank you, Himali. So the question with respect to that, so citation that was shown on the screen was in no particular order. Citations vary according to different formats. So when you go ahead for a competition in the rules, they will mention which citation format you have to follow. So it varies according to different formats. So Blue Book has very specific format for citations. Same with the case for SILC. So when you look into their formats, citation formats, you'll be able to figure out which is which. I hope that answers the question.
Thank you, Simi. Rishabh, there's another question which says, what is the difference between the title and the parties to the case?
Title of the title of the memorandum basically refers on whose behalf you are, which is the party which is filing the petition. Either it is the respondent or the appellant, or it is the petitioner. Anything. So, was I able to clear that doubt?
Did that answer your question, guys? Whoever has put that forward? Okay, anyway, the next question is it absolutely necessary? Annette Elizabeth Thomas asks if it is absolutely necessary to put in the abbreviations used in an alphabetical order.
Not exactly. You may choose to not put them in alphabetical order. It's completely up to you.
All right. Then the next question is, Selva Mary again says, shouldn't we use capital letters in a memorandum?
You can use, most definitely you can use for, as you could have seen in the samples that were shared over here, the statement or the question of laws were given in full capital letters. You can use capital letters for questions of law that were given and lay emphasis on particular line.
Yes. Then there's one more question put in on YouTube where they've asked, does the statement of facts need to be differently framed according to the side that's allotted?
You generally maintain neutrality in your statement of arguments. Say 90% of your statement of fact should be neutral. Maybe 10% or maybe here and there, or 1 point or 2 point can point out a certain event that was in your favor or certain event that gonna be not gonna be good for your opposing counsel. But on a general note, we do maintain neutrality.
There are other questions. There's somebody who's asked if there's going to be a different session on drafting language or legal language. So I think the thing about legal language is it is a subject in itself. So we won't be able to cover it within our workshops, but over the course of time, college will give you courses and certificate courses that will cater to that. So hopefully you understand legal language and drafting language there. So yes, and a lot of people are asking if you will be able to share the PPTs and samples, Rishabh.
Yeah, so regarding sample, guys, if you open the Microsoft Teams account for the Moot Court Society of this year, we have uploaded 6 sample memos over there from that have been taken from various Moot Court competitions, and they have won the best memorandum awards as well. Apart from that, sites such as Law Octopus or Memo Pandit or Legal Bytes, they too have a very large collection of memorandums that have been that have won best memorandum in all over across the globe. But point to be taken away for the first years are these are very advanced memos, so you need not get scared when you look through it. So apart from that, the presentations, yeah, it can be available on the Microsoft Teams.
Yes, there's one question that I've possibly missed out. Would there be a deduction of marks if there's an if the limit of pages exceed the given?
Yeah. Generally, in the rule book itself, you would find that for things that for which you might lose marks. So yeah, if you are exceeding the page limit, there would most definitely be a deduction of marks. Ali, are there any questions or any doubts?
Sorry, Rishabh, I can't hear you.
Are there any other doubts or questions?
Not that I can see on the chat, but if you could elaborate on a few things that they've asked, for instance, the page limit and everything.
Give me a minute. Okay, regarding page limit, so when when a particular college or particular organization sends out their mode problem, along with that, there would be a document which would contain the rules, regulation, and every other detail about it. And that document, they would have clearly listed out the number of pages for each and everything regarding how many pages you can take for statement of facts, how many pages you can take for arguments advance, how many pages you can use for statement of statement of arguments. And so you have to look through the document, and it differs from each competition to competition. So you have to look through the rule book, and there itself you would find the maximum number of pages that you can use.
Guys, are there any more questions? Okay, so there's just one pointer that I like to say, that in all competitions, the marks that you score in the memoranda is very important in the speaker scores, because the average of that is calculated and then your ranks are determined. So that's very important. And that is why drafting and the way you prepare or present your memoranda becomes essential. I'm sure Rishabh mentioned that already, but I just wanted to emphasize and reinstate that. So since you don't have many questions, why don't we do the other way around? Let's ask you about a little bit of what was said in Simi and Joe's session and Rishabh's session, so we know whether you understood what we told you. So Rishabh, a few questions for the audience, and we can have them respond to us.
Just give me a minute.
Okay, so I think I have a question. Can anyone tell us what statement of jurisdiction is? And at which part of your drafting or your memorandum does that come? You can key in your responses in the chat box. Anyone, guys? Statement of jurisdiction. Come on, Rishabh gave a long session on what statement of jurisdiction was. Okay, Ram, you're right. Before statement of issues. But what is it? What does it contain? Okay, so in the statement of jurisdiction, do you have to mention under which article that you are you coming before the court? Just give me a yes or a no. Okay, perfect. I think Smriti, Ram, and Purnima and Anvita also have given right answer. So yes, you have to mention under which article you come before the statement of jurisdiction, because the thing is, you can't go before any court and ask for any remedy. There are certain courts for certain remedies. So you have to mention under which article you're coming for the court to understand whether you should be approaching this court or not. Then I want you to name 3 important online sources that will help you, say, draft a memorandum. Okay, Selva Mary says Indian Qanun, that's right. Shravani is, I'm sorry if I pronounce your name wrong, but she says Okay, wait, I'm sorry. Yeah, Shravani says Manupatra, you're right. Abrar says Manupatra, Indian Kanun, SCC online. So all of you guys are right. Manupatra, SCC online, Indian Kanun, to an extent, Live Law, Bar Bench, Law Octopus are also sources of information or sources that you can refer to draft your memorandum. Then, okay, the next question is, what are the essentials of a cover page? Anybody, guys? Okay, Janvi says name of the competition. Rishabh, maybe you can just come in and say whether what they're saying is right or not.
Yeah, so the essentials does contain the team code, the name of the competition, the name of the forum, and the title of the memorandum, along with the color code of the front page.
Okay, yes, that's right. So yeah, name of the case, name of the forum. Okay, Visor.
Red stands for memorandum.
Sorry?
Red stands for respondents. Oh, there
Yeah.
was a...
Correct. Visor Rahman has actually given the name of the case, name of the forum, title of memorandum, and team code. You're right. You're absolutely right. Then we have a few more questions for you all. What's a prayer? Okay, so there has been a question posed to us, which says, where can you search for cases by selecting an act or statute alone, Manu search or legal search? So yes, in Manupatra, under legal search, you will have to search by selecting an act or a statute. There is an answer for what a prayer is. Yeah, Neha says, yeah, it's a relief claim by the parties. Okay. Then someone says asking the court for remedies or relief. Rishabh, are those correct?
Yeah.
Okay. So prayer is done. Is there anything you'd like to ask, Rishabh?
Himali, Rishabh, just a moment. I just noticed there's a question asking to elaborate on researcher's test. Since that is not essentially a part of drafting, I'll just answer that for you. So a researcher's test, again, first year, this is not relevant for you at this point of time. This is for the IRR rounds. But a researcher's test essentially is utilized to rank your researchers. So the computation of scores for the speakers is done during the oral rounds. For the researchers, we have something known as a researcher's test. Now, depending upon the competition, the terms and how the test is framed will differ, but usually it's an MCQ-based questions, and you can be asked anything from the case. It's not necessary that what you have written in the memorial is what you will be questioned upon, but a researcher's test can concern anything with regards to the proposition itself. So I hope that answers your question.
Yes, thank you, Diksha. So we just have like one more question from the first session that Simi and Joe did. So what is a citation in general? Like there was an elaborate session on what a citation is. So can someone can any of you tell me what citation is? Okay, Diana, I'm sorry if I pronounce your name wrong, says reference. Okay, you need to elaborate a little more about reference, because why is it that there's something called citation? Why is it that you have to? Okay, reference to a particular legal source. Yes, Anvita is right. It's because every source that you refer to, I'm sure all of you have heard of what plagiarism is. So you cannot take someone else's work and call it yours unless you give due credit to them. So citation is a manner in which you present that. You tell whoever, when you're drafting, you tell the person reading it that you've taken that particular thing from another source. And that's also a manner in which, so how you give credit has a particular pattern or a format, and that is citation. And there has been an elaborate session on it before. So yes, all of you guys are right. Kavya says it's the source that contains details relating to the case. Yes, relating to the case, not just case, it can be anything. It can also be an article and you can have citations for it. But yes, in a legal document or in a memorandum, it's usually your reference to a precedent or a case law. So is there anything else you guys want to ask us now? Anything, guys? Yes, Puneet says it basically shows from where we've derived the information with reference to a particular study of a case. Yes, you're right. Okay, Rishabh, is there anything else that you said and you want to ask and make sure they understood it? Okay, there is Janvi who asks us how to write citation for articles, books, or websites that we refer to. Okay, that's a good question. Simi, would you like to intervene and answer that question?
Surely, Himali. So, Janvi, how to write citations. So, as a researcher, when you start out, it's going to be a bit of a task for you to understand how formatting or how citation works. So, for example, if you're using Blue Book and you want to cite a book, so the citation format goes the author's name first, comma, title of the book either underlined or italicized, comma, the publisher, then the year, then full stop. So this is just for Blue Book 2020 edition. So there are different editions for one standard citation itself. And there are different types of citation that we follow across India. There can be standard Indian citation, there can be Oxford, there can be Blue Book. So there are various citations. So when you start, it's going to be nothing but looking at when you download a format, they will give you example like how we showed on the slide. It's nothing but looking at the example, looking at how it's formatted or how it's given, and we try to make it exactly the same. That's how you start. But after you work on one memorandum, second research paper, again another memorandum, you will get the grasp of it and you'll be able to do it very quickly and easily. So it depends upon it depends upon your skill and task. And I can see, can we use citation generating sites? So what happens with these sites is that I cannot say yes or no here because that's up to you. But from my personal experience, every time I've tried one of these generators, it has never come according to the edition that we require. And every different site would sometimes give it according to the edition that they are using their system or search engine on. So we might not get what we want. So it's always the task of a researcher to know basic citation techniques on the tip of your hands, and then to follow it is time consuming. No, I'm not denying it. It is time consuming. You have to keep 2 to 3 days apart just for the purpose of formatting your citations, but it's going to be worth it if you're going to do it on your own by following the format given. I hope that answered both the questions.
Simi, there's one more which says, can we use the inbuilt citation tool in Word?
It goes same way. So as you're using citation generator, you definitely see, again, I'm not going to say yes or no, it's the choice is yours. However, if you're going to go by that method, after you do it, come back to the edition that you're supposed to follow, go to the format, see if it is accordingly, see if it is following the same pattern, then probably, or else I would ask you not to, but that would be double task for you to use the generating site and then come back and check and verify. It's going to be a task in the beginning, but later on you will find it's nothing, but it's just an amazing, easy work that you can do. So it's better you do it on your own. And as research students or as law students, it is really required for us to know citations on the tip of our hands. It will be useful even after you graduate.
That's right. Actually, I just want to add on with my personal experience. I'd actually submitted an article to one of these NLSs, and they reverted back to me saying that you've used an automatic generator for citations, and we'd like you to. They actually sent me a document containing the citation format, and they told me to look at that and change my citation. So sometimes you might also be faced with embarrassing situations like that. So I'm not going to say whether, like Simi said, whether you should avoid or not, but depending on who you're submitting to and where you're sending your materials, be careful in how you cite resources. Yes, so I think with this, we come to an end of this. We'll just give you 2 minutes. Anything else you guys want to ask, you can key in the chat box and we'd be happy to answer from the session, the first session as well as this session. And then we'll just conclude this session. Okay, so in case there's nothing, we can just conclude. Rishabh, I let you conclude the session.
As it has been pointed out by each one of us, that memorandum is essentially the 50% of your scores for in a moot court competition. Though it may sound like a lot, but once you start working on it, it is easy. You just have to go with. You just have to just keep working and not just give up. And you can refer to the various the best memorandums around the globe, which are available around various sites, and you can use it as a sample, but don't get intimidated or don't try to copy paste everything. Because each and every memorandum has their own style, and everyone has their own style of writing. And in case you guys have any other doubt, you can reach out to us. Thank you so much, guys.
Yes, thank you guys. The Google form link has been circulated on the chat boxes. I hope you guys like key in your information and fill in so you can get the attendance. It's also on YouTube, I hope. Yeah, so just fill that in. Guys, the link will close at 11:30, so please fill it in before that.
Guys, I hope you all have filled in the attendance link. Kindly note that it will be closing by 11:30, and do not send us messages. We are not in a position to reopen the links once we have closed them. So kindly fill it within the time limit. The next session will be beginning at 12 o'clock. It will be addressing the essentials of mooting as well as the oral rounds. So Kindly join in by 11:45 and join in the same link. Thank you.
Hello, everyone. Good morning and welcome back. Hope you had fruitful sessions with the MCS. The next session will be led by Ms. Himali Sylvester and Ms. Diksha Garg on the general overview of the kinds of moots and the do's and don'ts of the oral rounds. I now invite Ms. Himali to discuss about the basics of mooting. Over to you, Himali.
Thank you, Joe. I'll just share my screen. Yeah. So this session's going to be slightly lighter than the previous ones because it's largely going to be about why one should moot and what's the essentials of mooting and everything. So the first thing that's important for us to know is what mooting is. Okay. So I'll just give you a general overview of what the word moot means. So the word moot itself actually refers to a problem or a certain statement that's actually undecided. So as to say that there is no right or wrong to that statement, it's just an open-ended statement, and whoever has a more convincing case or is able to substantiate that particular problem largely wins. Now, in the scenario of what we are talking about, what possibly is mooting or a moot court, okay? So it is actually a simulation of a real court. Whatever happens in a real court actually happens in a moot court scenario as well. So there is a judge that's sitting. I think there's a picture that I've put towards my right. And in that you can see a panel of judges sitting and like a speaker standing up to talk. And then you also see two court clerks sitting there. So that's exactly how a moot court usually is. So mooters are actually representing as lawyers there. So there's an opponent counsel or let's just say petitioner counsel and the respondent counsel. And then they're making their submissions right there. And then there's an adjournment of the case also in certain cases. And there's a brief judgment delivered or there's some feedback given in the form of the judgment, okay? Now, a lot of people actually have this doubt, like, is mooting the same as public speaking and debating? So like over the years, like most of us start off with start off as debaters, and then we move on to being mooters. So the difference between debating and public speaking, debating and public speaking and mooting is that in mooting, you actually have to observe a certain set of procedures. Like you go to the court, you can't talk the way in which you would talk, say, in a debate competition. You need to observe certain kind of language and certain kind of procedure. Diksha will deal with what sort of procedures you have to observe a little later. But it is for you to note at this point that you can't just go, you might have a persuasive case, but the manner in which you present it is also very, very important. Okay, so that's a little bit about moot court in itself and what it actually means. Then we have, say, just a second. Okay, so then we have, stuck. Okay, anyway, then we talk about the basic reasons why it is essential for one to moot. It is necessary for most of us to moot because one, it improves our thinking on spot skills. Like it helps us think on spot. That is one of the reasons why most people moot. Secondly, it helps us with our research as well. Most of us are able to do our research well because we start mooting quite early. Then it helps us work in a team. So most moot court competitions happen in a team, right? So because it's done in a team, it also helps us work in a team environment. And then the next thing is that the end of the day, whatever you do in a moot court scenario or in a moot court competition prepares you to be a little better lawyer. So what it prepares you to be a better lawyer, and that's why pursuing the skills of lawyering is one of the reasons why people have to go for a moot court competition. So then we also have so then we have benefits of mooting, as I just told you, to demonstrate the interest in advocacy and so on. Then we have basic processes in mooting. So what are the basic processes? Now, you guys have already gone through sessions of research and drafting. So of course, there's a problem, as I told you before. There's a proposition at hand, and you're expected to analyze that proposition. That's the first basic step in mooting. And then you go on to research on the relevant law. And the first session, you've already learned about how you can go about your research. So as lawyers and in a moot as aspiring lawyers and as mooters, what we have to do is substantiate the problem. More than just logic, yeah, logic is obviously there, but more than just logic, we also have to apply the law and convince the judge why what we're saying is right or wrong. Okay, and you've already learned about what the sources of law, etc. are. Then we move on to the next step, which is preparing written submissions. Written submissions are also very essential, as has already been told before in the drafting session, because it gives you a convincing case. It's a craft in itself. And because the judge reads that the first before listening to our oral arguments, written submissions are absolutely very important. Then the fourth step is oral arguments. That's the final, where you convince and substantiate your point of view. So usually, whatever moot problems you get or propositions you get are set in areas of law or set with topics that are usually not decided, as in the subject is moot and is open for discussion, or there's no right or wrong in that. And I've already told you this before as well. So after the basic processes of mooting, we also have, are you able to see my screen?
Yes.
Yes, ma'am.
All right. So, so that is what happens in a, so now we can look at what a team composition is in a moot court competition. So largely in any moot court competition, you have 2 speakers and 1 researcher, but sometimes you also have 2 speakers only, that depends. Then you have certain international moot court competitions like for instance, like Manfred Latz or Jessup, where you're allowed to have more than 1 researcher. So you usually end up having 3 to 4 researchers. At the end of the day, people speaking in the competition will still be 2 people only. So it's always 2 speakers. So that's how a general external moot court competition scenario is. Now, in the context of IRR as well, it's the same. It's the same norm that applies to general moot court competitions, which is 2 speaker, 1 researcher, or just 2 speakers. Not sure why my screen is not moving, but whatever. So yes, so that's what happens in a moot court, in your IRR as well. That's the norm and that's the rule right as of now. Then we move on to the team composition as remains in AMCC for the first year students. So in AMCC, the AMCC, the composition is a sole counsel composition. So sole counsel is an individual counsel. So there's just 1 person arguing before the judge, but so he or she is the researcher and the speaker. So the reason why this is done is usually when you start off, it's better to be able to think on your own. So it's better to research on your own and learn to speak on your own, which is why usually, yeah, thank you. Which is why usually there are 2 speakers and 1, which is why in an AMCC setup, we're allowing sole counsels to go. Okay, so that's the thing about AMCC. Diksha, you can go forward with the slide. Yeah, done. So I've already told you about the team composition in IRRs, and then there's AMCC where you go as sole counsels. For now, you can see that picture that I've put in internal ranking rounds. Usually that's in a physical moot court competition. That's how you are before. Not that many panel of judges, maybe like 2 or 3 judges. Usually you standing with them. And Then we have AMCC Sole Counsel. Can you please move on to the next slide? Yeah. So it's an individual representation, as I've told you, but you're still arguing, like you were given one side and you're still arguing against another counsel who's also individually there with the other side. So it's just the same thing. When you go to IRRs, it becomes team, like two people are speakers. When you're in AMCC, it's just you singular. Okay. So now we'll move on to certain legal terminologies. So this is where I'm going to quiz you all, and I expect you all to like give your answers in the chat box. And if you're able to unmute yourselves and answer. So you've already like learned what written submissions are in your previous slide. So can anyone tell me what written submissions are, memorials or memorandum? I mean, it's very easy because Rishabh literally did an entire session on that. So just like a quick answer on what memorandum is. Anyone, guys? What is a memorial or a memorandum? You can raise your hands, keen in the chat box. Okay.
Himali, there are a couple of answers in the chat. Would you want me to read?
Yes. Yeah. Go on reading it.
Okay. So a document consisting of facts, issues, jurisdiction, arguments, etc.
Correct. You're right. So that's Ram's session, right? Yeah. Okay. You're right, Ram. It is a document consisting of facts, issues. Basically, the final document that you submit to the competition or to the place of competition, the one that's hosting the competition. Okay. So you guys must have heard of a common term called PIL, which keeps going around, right? Like everybody, like probably newspapers also, people say there's a PIL that has been filed. So can anyone tell me what PIL? Don't just give me the full form of PIL. Also tell me what PIL is. Okay, Ram again says it's public interest litigation. Yeah, yes, Ram. Okay, you're right, public interest litigation. But what is public interest litigation? Yes, Zoe, if you've raised your hand, you can go ahead.
Hi, good morning. Am I audible?
Wow.
Yes. So as Ram mentioned, it's kind of self-explanatory, public interest litigation, meaning that you have justice available to those that need it. In this case, generally it's used for like socially disadvantaged groups, and it was brought in by Justice P.N. Bhagwati, if I'm not mistaken.
You're right, you're right.
Yeah.
P.N. Bhagwati and one more. Can you guess the other judge's name?
I can't recall, I'm sorry.
So it's Justice Krishna Iyer and P.N.
Yes.
Bhagwati, yeah, who introduced PIL. Okay. Yeah, you're right. But there's, okay, so Zoeb, since you answered, let me just like follow up on that. I'm sorry, like if you feel like it's too much, but yeah. So what I wanted to ask you is, so what stands different? Like, yeah, I mean, there are other ways in which you can represent socially disadvantaged groups also, right? So what stands different for PIL? Like,
if I'm not mistaken, you can go directly to the Supreme Court with a PIL, if
right.
I'm not wrong.
Partially right. You can go to the High Court and
High Court as well.
Directly.
Yes. You don't have to follow that like due process of.
You don't have to exhaust local remedies. That's basically how it works. You don't have to go to the lower courts. Yes, fine. So then have you guys heard of what a writ petition is? Can anyone tell me what a writ petition is? Zoeb, just let me see if there's someone else willing to answer. I'm sorry, but like, yeah, PIL is a form of writ. Okay, that's very interesting. Like, yeah, it is. I'm also very intrigued by that answer. The high courts are easily, yes, you're right. Kavya is also right. Anyone writ petition? Okay, then Zoeb can go ahead answering if there's no one. Okay, Kavya has raised her hand. So, Zoeb, is it okay if I let Kavya go?
Am I audible?
Yeah.
I'm so sorry. I was trying to raise my hand from long, but I don't know why that option was not working for me. So writ petition is basically like an order that is given by a higher court to a lower court. Like that will tell them to do an activity or not do an activity. So that order basically tells them what has to be done.
Okay, so there are many forms of writ. So what you are suggesting is one form of writ.
If I'm not wrong, in the bridge course class, we had learned about various like habeas corpus, mandamus.
Correct, exactly. So what you are saying comes under one type of writ. Can you guess what that writ is?
I'm not really that sure about that.
Okay, fine. Okay, so there's an answer here which says, yeah, mandamus, correct. Mandamus, and there's one more person who says it is an application before the court. Okay, so under Article 32 and Article 226 of the Constitution, special provisions have been carved out for writs. They're called writs, and there are 5 types. I'm not going to go on burdening you with what the types are and everything. It's just understand that it's a special remedy that's given only to the higher, for us to approach the higher courts and the Supreme Court and the High Court in certain situations. Okay, so yeah, that's all. Okay, so the next will be, okay, Kavya says Article 32 is the heart and the soul of the Constitution. Yes, for sure. Then, okay, civil petition and criminal petition are quite obvious. I'm not going to ask you what they are. Does anyone know what an appeal is? Neeraj, yeah, Neeraj, go.
Yeah, am I audible?
Yes, you are.
Yeah, so basically an appeal is basically going to a higher form of court, and or appellate tribunals in itself exist independently. Like for example, there's National Company Law Tribunal, and then if you're not satisfied with the decision given by the NCLT, you can go to National Company Law Appellate Tribunal, or you can go, if it's for a district court, you can go towards a high court or stuff like that.
Correct, you're right. I just have like a follow-up, I'm sorry, but like because you answered. So can everybody appeal? And like, can everybody appeal? And in the parties, can both the parties go for an appeal if they're aggrieved by the order, or is it just the losing party that usually appeals?
I'm not exactly sure, I'm sorry.
I'm not gonna answer that. Let you find that on yourself. Okay.
I guess to me it makes sense. Like, is it the losing party or?
Yeah, usually the aggrieved party.
Yeah.
I don't think there's a bar on who can go appeal. Either party can, but usually the aggrieved party. Why will the winning party go? Yeah. So fine. So just the next slide, please. I'm sorry, there's somebody who said any party that's aggrieved, but there's a bar on time. Yes. So now, like, let's not go too deep into law, okay? Because like, it's just generally know what appeal is and everything. A bar on time and everything, you'll come to that when you come to like my years of study, like 5th year and stuff, you'll understand what limitation acts are. Then we'll go. I see Ramaseshan's hand up. I think Neeraj is just remaining from the previous time, or do you have something to ask? Okay. So, right. Fine. So then we'll go to certain other things. Okay, what's a bench, guys? Like you've heard of, like the bench said this, bench said that. So do you guys know what a bench is? Anyone? A group of judges presiding over a case. Okay, so just like a general quizzing, do you guys know which case had the largest bench till date? Anybody? I'll give you a minute or two to think and then respond. It's a famous case. I mean, all of us know it. Yeah. Nitin Babarjang replies, Keshavananda Bharati. Yeah, you're right. Keshavananda Bharati was a 13-bench judge. So that was the first time it was called a full bench. So yes, Keshavananda Bharati. For those of you who don't know, Keshavananda Bharati is a very famous case law on basic structure doctrine. Okay, you'll learn it over time for sure. Fine. So now this is about bench and everything. So now we'll come to like oral rounds, certain words used during oral rounds. I know you guys haven't had a session on it yet. Diksha will come to that soon. But like before that, I'll just like give you a little, so let's just talk about what, say, a rebuttal is. Anybody knows what a rebuttal is? You can raise your hand or key in. Anybody, guys? Okay, Anna Elizabeth says counter argument. Yes. Okay, so since you've saying counter argument, who counters whom in a rebuttal? Is it the petitioner countering the respondent or the respondent countering the petitioner? Okay, in a court, when counsels get a chance to rebut the opposing counsel's argument after they're done presenting, petitioner goes first, ma'am. Yes, petitioner goes first. Okay, in the case of sir rebuttal, who goes? Yeah, Kavya, you were asking who's arguing. The petitioner always goes first. In a case, at least in the scenario of a moot court, the petitioner is always arguing first. So the petitioner really hasn't heard the arguments of the respondent. So the petitioner is given a chance to counter or say something against what the respondent has said. And sir rebuttal again is a response to the rebuttal that's given by the respondent. Okay, or the defendant, as the case may be. Yeah. Yeah, so that's a little bit of quizzing on certain legal terminologies. So now we'll move on to mooting, like moots and external moots, how we can go there. So before that, let me tell you why internal mooting rounds are important. Internal mooting rounds are important because we've already told you it helps you think on spot, generic, it improves your research, drafting, and oral skills. But most of all, guys, only if you qualify in your internal rounds will you get to represent college in external moots. So that's very, very important. These are qualifying rounds. It is like a practice session. What you go through internally in college is like a practice session for you to be able to face a panel of really, really experienced judges outside as well. So it's very important for you to give it a try inside college because one, it's easier, it's among your own friends, it's among people you know who are familiar, and there are people who help you out. When you go for external moots, people aren't helping you as much and you're completely on your own. So it's absolutely important for you to try going for the internal mooting rounds. This is especially for the first years who think it's difficult or anything. It's not that difficult. You just have to research, and you always have your seniors and your teachers to help you with the procedure. Of course, teachers are not going to help you with the proposition itself or anything, but anything to do with the procedure and so on, they will always be able to help you with the law or anything. So you must always go through the internal rounds to know what mooting feels like. Immediately going and facing an external panel is not advisable, and that's going to be worse for you. Okay, so that's the importance. And of course, like it helps you pursue the skills of a real lawyer. Like the more you move, the more you understand what it feels like to be a lawyer in a real court, right? Okay, so now I'll give you an overview of what kind of moot courts you can go to and how it is usually divided. So moots are usually classified on under three headings, say the procedure. Now, what is procedure? You have civil moots, you have criminal moots. Criminal moots are called trial advocacies for those who don't know. And there's also an increasing trend of a certain kind of moot called arbitration moot. Arbitration is just an outside court settlement. Instead of going to a court itself, a constituted court, what you do is you sort of nominate or take up a third party who's going to decide on your dispute or your conflict. So that is arbitration, and it is increasingly a less formal. It's a less formalized way of conducting yourself. So, for instance, say like this will be dealt with later, but for instance, in a normal court, for instance, if you approach the judge as your lordship, maybe in arbitration, you will only have to say Mr. Arbitrator or Sir Arbitrator, something like that. So it's a less formal version of mooting. Okay. Then there's also classification of moots based on areas of law. Like there are several areas of law, like constitution law, tax law, right? Can you please move to the next slide? Yeah. So here you see different areas of law. These are usually like overarching areas of law that moot court competitions usually target. Constitutional law is usually how people start off. Then you go on to more nuanced versions like tax law, corporate, antitrust, space law, which is also emerging now, and all of that. So this is based on area of law. Then the third classification which comes is based on the level of competition, which is of course national level and international level. So from what I know, the mooting circuit is one of the most cleanly maintained circuits in the world in terms of competition. So as to say that only if you qualify certain national rounds will you be allowed to go for international rounds. So that's how well maintained moot court competitions are. So you can't just apply for an international level competition. You have to go for a national round. And then if you qualify there, say top 20 teams or something are allowed to you're allowed to represent in an international competition. So that is divided on the basis of competitions. Then now I'll walk you through some important competitions that are there. So first I'll look at international ones, then I'll tell you about some important national, then we look at Bangalore itself. Okay. So the most important, so William Wiz is something you must have heard. They deal with commercial arbitration moot. So commercial arbitration, I've told you what arbitration before is, but arbitration also has two forms. Like there's commercial arbitration, there's investment arbitration. So William Wiz usually targets commercial arbitration moots. Okay. Then you have on intellectual property, which is always organized by Oxford School of Law. They organize this moot court competition. Then there's a very famous criminal law moot court competition organized by International Criminal Court itself. Then you have the space law moot court competition. Air and Space is organized by Leiden University in Netherlands. And this Manfred Lad space law competition is taken up by any university yearly on an annual basis, sometimes by a university, say in the US, and sometimes a university in Europe. You can't really say. Whoever wins the bid, maybe. Whoever wins the bid organizes Manfred Lads every year. So that's that. Then you have human rights moot organized by the Red Cross Society itself. Then you have something called Stetson moot. Then you have Jessup's also. So Stetson always targets environmental law. Like it's by principle that all their propositions are related to environment law. Okay, so that's the overarching international moot court competitions. Now I'll come to certain national level moot court competitions. So there are national moot court, as a matter of fact, NLS International Arbitration Moot is a very famous national moot court competition. It's like coincidentally, it is also one of our local moots because NLSIU is in Bangalore as well. So yes, so that's there. The Bar Council of India organizes a moot court competition. It's generic. There's no particular topic that it targets. Then you have NUJS in Calcutta, which organizes on corporate law. Then you have NLU Jodhpur, which targets competition law, which is like antitrust law. So then in Bangalore, we usually look at NLSIU, as I told you before. And we also look at Christ moot court competition and University Law College's moot court competition. So these are three that most people look forward to. Then besides the ones that I've already mentioned, NALSA organizes moot court competitions regularly on different subjects. Like it had one on human rights, it had one on international law, and now recently it has notified one on competition law as well. So NALSA gives you competition, gives you many opportunities to go for their moot court competitions. So that's there. So these are the most important moot court competitions. So there's something also that I'd like to tell you. How do you pick a moot court competition? Okay, so you pick a moot court competition based on your interests, one, right? So, but when you start off, it's always better for you to start off on constitutional law. You start off on constitutional law because that's easier to research, and also because consti law is something you do in your second year. I think most of you guys do consti law in your first or second year itself, right? So that's why it's easier for you to start off with constitutional law, and research and precedents are also easier to find. Then you move on to areas of interest that you like. For instance, if I like competition law, it's better for me to target competition law. there is an increasing trend where like me and my friends, like we just look at the popularity of the competition and then we just go for the competition. I think that's something you shouldn't be doing. Okay, yes, the popularity of the competition matters, of course, but what you should look at also is whether that area of law interests you. Like, for instance, if antitrust laws don't interest you, don't take up that. Okay, so so before you sign up for a competition, do enough research to know if you actually like what you're doing, right? Then finally, yeah, so that's all from my end. Just the last slide, which has an image of our new college building. So as I know, there's a new moot court hall that's going to come up there. So I hope all of us moot and are able to use that moot court hall that comes. So we're just telling you, you can only use the moot court hall if you participate in internal ranking rounds. So I hope all of you come and participate in our internal rankings. So yes, now I'll hand it over to Deeksha.
Thank you, Himali, for that really great presentation. And thank you all for actually just paying attention and staying with us for so long. Very honestly saying that when we did organize, we thought that students might be bored by now, but we're really happy to see that everyone's interacting and actually participating. So I will be dealing with the oral rounds of the moot court competition, which is arguably the most happening sort of rounds that, at least for me, as a speaker, I do prefer the oral rounds. As researchers, you may argue differently. But yes, this will have a brief overview of what happens in an oral round. I'm sure most of you would have been there for earlier presentations on similar issue. So if it's repetitive, just bear with me. But these are really basic elements which need to be followed. Throughout the course, if you feel that I am actually going too fast or you want me to slow down, just key it in the chat or unmute and let me know. So yes, coming to the presentation itself, I will be doing a very brief or in basic overview. So when I say overview, it is exactly that. It means that you need to actually go and look it up a little more and understand a little more. This is just going to be targeting the basics of what to do and what not to do during the oral rounds of a moot court competition. So understandably, like my earlier colleagues have mentioned, that the team composition in most situations is comprised of speakers and researchers. Depending upon the rule of the competition, you might have varied number of speakers and researchers. In the most general competitions, you would have 2 speakers and 1 researcher. Understandably, during the actual moot court, the oral rounds that is, Speaker 1 and Speaker 2, which is the speakers of your team, will have a wider role to play than the researcher. But this does not mean that the researcher's role is not relevant. So to just give you an idea, especially in physical moots, you get an opportunity for the researchers to actually help their teammates by helping them answer questions. So you are allowed to pass notes. You cannot obviously speak because that will violate the court mannerisms and court procedures, but you can pass off notes. So in virtual moots, what usually happens is they enable you to use the chat box option for the researchers to help the speakers. The roles of Speaker 1 and Speaker 2 are slightly different. While both of them will essentially have the similar matter, there are some stuff which the Speaker 1 additionally needs to do. So I will be addressing that just in a couple of minutes, but yeah, that is the general idea of how the team dynamics and composition work during the oral rounds of the competition. Coming to the dress code. So this is a formal environment, like Himali showed you the picture. If it's a physical moot, it is going to be similar to how it was shown. Even if it is not a physical moot, in a virtual moot as well, you do have to follow the dress code, which is prescribed in your rule book. If it's not prescribed, by default, the dress code is going to be black and white formals. The reason that I and most of us do not prefer wearing college uniforms or do not allow for college uniforms is because sometimes college uniforms have college logos or some kind of an identification mark, which really defeats the purpose of remaining anonymous and confidential throughout the moot court. Please notice that I think all of us till now who have spoken have paid much emphasis on confidentiality and anonymity. The reason being that if there is any revelation of your personal details, that could lead to actually immediate disqualification. That might not be followed very stringently across competitions. They might actually pay a penalty of just cutting your marks or something, but definitely there is always a penalty. Coming to addressing the bench. Now, like the earlier session specified, a bench is essentially the composition of the judges. So it will have all the adjudicators over there, and depending upon which court or which forum you are before, you can choose either of the ideologies, either of the references that are given here. So the entire question of how do you know which court you are before will be mentioned within your statement of facts. So it's very essential that you read your statement of facts very carefully so that you identify which court you are before. If you are before a tribunal, you can address to them as sir or madam. If you are before a lower court, that is anything lower than a high court, you would refer to them as your honor. In the higher courts, which is the Supreme Court or the High Court, you would be referring to them as your lord, your lordship. And in the international courts, you refer to them as your excellency. This is restricted to moot. I understand that not many would actually be too rigid about how you address them as long as you're respectful towards them. But not knowing how to address them might actually cost you marks. So it's always beneficial that you do pay attention on how you're addressing the bench in itself. So I will briefly explain on what this presentation is targeting. I will not, like I said, I will not be explaining in details of every aspect of your oral speech, because this is something that you will actually pick up once you are mooting yourself. But the essentials that is required in your oral speech, which is like your structure of your speech, how do you answer a question when the judges pose them, and how do you maintain a general tonality of respectfulness, is something that would be targeted here. It has been said in the drafting session as well, you have a format of how you go about it. You mention your facts first, your issues which you have raised, the arguments that you will be putting forth before this court, the case laws that you have cited, and prayer. So the bare structure or the skeletal structure would have all of this. Before I get into the entire thing of how do you frame the speech, etc., the most important aspect to understand is that even if it is a moot court and the judges themselves might not be sitting High Court or Supreme Court judges, there are certain procedures that you need to take note of. And the main part is that you take permission for everything that you do during the moot court. There is no way around it. If you at any point do something that the judge is not explicitly given permission to you for, you will actually be losing marks in terms of court mannerisms or in another way, depending on who the judge is. So where the first permission, when you say I seek the permission to approach this bench, is essentially asking to begin the presentation of your case. So like you saw in the earlier picture that Himari demonstrated, the speakers stand before a podium, right? So in a physical moot court situation, your counsels are actually sitting on either side of the court. And when you seek permission to approach the bench is when you get up and go behind the podium to actually begin the presentation of your arguments. So that is the logic behind how it was formulated, and that is still followed even in virtual courtroom situations. When you address to yourself as the counsel, you do not really call yourself speaker one, speaker two. It's just, since you are advocating, you would refer to yourself as counsels. So counsel seeks permission to address this bench collectively as your lords or your lordship and ladyship. So this becomes important in a situation where you have one lady and one gentleman sitting at the podium to judge you. Usually, like I said, not many get hung up on the dynamics of how do you address them, but it's always better to seek permission at the beginning stage and clarify all of this and then move ahead. The third point is where the role of the speaker one and speaker one slightly varies. So as speaker two, you can ideally just begin with the presentation of your arguments and issues. But when it comes to the speaker one, it is also your duty to let the court know which side you're representing, The division of time between yourself and your co-counsel, keep in mind, when you say co-counsel, it's the speaker too, the issues that you will be dealing with and any other information which may be pertinent for the judge to note. So you frame your sentence something like, it may please be noted that counsel 1 has a time of about 8 minutes, and I will be dealing with issues 1 and 2 combinedly, while my co-counsel has a time of about 10 minutes and will be dealing with issues 3 and 4 separately. So this is ideally your second or third sentence that you would be saying. This is where the roles slightly alter. Then you move on to the presentation of facts of the case. Again, something what in general is expected out of the counsel 1. But if the judge wants you to, then you can, then even the second counsel might have to deal with the facts of the case. So it's no set rule that only the counsel 1 has to prepare. Even counsel 2 might have to prepare and present the case laws. Statement of facts. Then you move on to taking permission for presenting the arguments of the issues 1, 2, and 3. So this is ideally the preliminary permissions that you're taking. This is even before you've actually started talking about what is the substantive part of your argument or substantive part of your draft of your memo. So this is something that is termed as preliminary permissions, because this is even before you start your main arguments as such. So when it comes down to the structure, to actually understand how do you subscribe to framing the entire thing, my suggestion, and I think all of us would actually emphasize that you do this as speakers, always frame your entire speech, whether it has to start from the first permission till the last sentence that you are going to deliver before the court. The reason being that you will, when the question and answers are being thrown at you, it is very easily get sidetracked. If you do have your written speech before you, not only would you have sorted the issue of managing your time, you would also be in a position to come back to where you left off and then continue. So it is very, very important that you actually frame your entire speech to the last thing. So when I say you form your skeletal argument sub-issues first, this is essential for you to give a roadmap to the judge, because ideally the judge, you need to get them hooked on to what you're going to be speaking. To actually enable for that to happen, you would have to give them a roadmap of what kind of issues you're dealing with, what is the sub-issue you're dealing with, and the important case laws, etc. I will come a little bit into how do you frame that in the second part, which is the Barak formula. Now, Barak formula is something that Simi and Rishabh touched upon when they spoke about the research and drafting part of things. I will be talking to you about how do you actually utilize the Barak formula when you are delivering your speech. And lastly, this is really, really important, never make an introduction. By introduction, I do not mean that you cannot say that I am counsel 1 for petitioner. That is okay. But the moment you say that my name is Diksha, I am from St. Joseph's College of Law, that becomes a problem, because that would lead to penalty in form of points, as well as could lead to disqualification, because you're not supposed to reveal any sort of information pertaining to your personal details. So please keep that in mind. The introduction in a moot is always, I am counsel 1 for the petitioner, or I'm counsel 1 for respondent, or something like that. Coming to the Barak formula. Now, before I begin, I'm just giving you a disclaimer that it is going to sound really repetitive, but that's the point of it. So you first start out by actually stating your bare assertion. Now, for instance, your proposition or your statement of facts deals with the CAA issue. Since I'm sure many of you would be familiar with it, I will take it up as the CAA issue, which was the Citizenship Amendment Act. And you are coming forth for the petitioners. You want to explain to the judges that and your first issue is dealing with this as well, that the entire enactment in itself is violative of Article 19. So you would frame your sentence something like, the council submits before this honorable forum that the impugned statute is actually violative of Article 14 of the Indian Constitution. That is your bare assertion. You're essentially telling to the judge what exactly is the issue that you're dealing with. Then you would add on information when you explain the rule of law itself. So you would say that Article 14, if your lords pay attention, actually deals with equality, equality before law and equal protection of law. So clearly you specified what is the provision of law and what are the main essential ingredients within this, which is equality before law and equal protection of law. Then you come to the analysis aspect of it. So now here is where you will bring in your case laws, you will bring in any additional information that can support your argument to actually state why exactly and how exactly is this particular statute violated. So you can say that within the Article 14, it is mentioned that all citizens, irrespective of caste, creed, color, are liable to be treated as equals before the law and get equal opportunity, equal protection of law. However, by enacting this sort of a statute, the government has clearly violated this since they're trying to create an additional criteria when none exists. All of that is again details that you will get into, but I'm just like telling you how your sentence would at the end of it sound like. So when you come to the conclusion aspect of things, conclusion is essentially you repeat the bare assertion. That's you would say something like, thus, in the light of all the arguments raised, the council humbly submits that there has been a clear violation of Article 14 in this instance. So like I said, it sounds more of just repeating what you have said first and then adding on information. But that's the point of it, because the judge then can clearly see what is your assertion, as well as he can identify what exactly are the case laws that you've targeted. Now, coming to the key points that you need to keep in mind while you are making your assertions. Firstly, like I said, every argument needs to be backed by an authority. An authority here is essentially a case law or a statute. The hierarchy that I've listed out here is actually in terms of the binding value that each of them have. I'm not going to make you say what each of them are again, but just to start off with, the legislation has the highest binding value. So if you have a provision of law which is in favor of you, ideally most moot courts wouldn't really give you something so easy where you have a statute entirely favoring your argument. But if you are lucky and if you have something like this with you, use it as it is, because that's the best case scenario. Coming to the precedents. Precedents, like we have been discussing since morning, is essentially case laws. How do you decide which precedent to use? Because keep in mind that in your memorandum, especially if you're going for a constitutional law moot, you can have anywhere between 50 to 100 cases. So it is very difficult to analyze which judgment is the most relevant for you to use in your oral speech. Obviously, you cannot go and tell the judge each of the 100 judgments or precedents you followed. That's just not going to work out in your favor. So you need to choose the best cases. Firstly, you decide in the terms of how relevant it is to your facts. When you're citing, there are some decorative case laws that you might use, especially in consti moots. But when it comes to specific fact-oriented case laws, that is what benefit you the most and can be used in the course of your oral argument. Then to decide which case to actually place where, you decide in terms of the year. The latest case, the better. By the higher bench, the better. And by the highest court, the better. So this is how you decide which precedent to use, because ideally in your oral arguments, you would be using somewhere around 5 or 6 cases at best. You are expected to actually even know the facts of some of them. So it is better that you use stuff which is related to the proposition at hand, as well as deals with, the specifics of the issue itself. When it comes to domestic problems which deals with domestic law, books and journals do not really have much of a value. Like, as in you can mention them, but at best they have persuasive value. I hope you understand the difference between authoritative and persuasive value. If you don't, you can just let me know. I'll explain it to you towards the end. But books and journals do not really have much of an authoritative value in terms of authorities in itself. But if you are dealing with an international law problem, they have a slightly higher persuasive value. So in that case, you can use them. So this is when you are making your first submissions. Then you come to the rebuttal round. Again, you are not debating. So you have to understand the difference between a rebuttal in debate-wise and rebuttal in terms of moot court. In a debate, you can actually counter their argument in itself. But in rebuttal for moot courts, you not only have to target their argument, You also target the authorities that they've cited. This is where your knowledge of Manupatra and everything comes in handy, because Manupatra actually lets you know, they have an entire, actually, I don't know how to explain it, but they have an entire list of symbols, etc., which help you understand which cases have been overruled, which cases are still pending, or which cases have been appealed before the court. So this is where it helps you, because it minimizes your time for research. What you can do is to actually say why the opposing party, whether it be petitioner or respondent, their authorities are not relevant. So you can say whether it has been overruled by a higher court, it has been actually decided by a lower court, so it has no bearing on this court. And you can also say that it has been superseded or something like that, because there's been a statute which came in to the opposing value. So this is how you deal with the rebuttal and moot courts. If you simply target their arguments, you will lose out on scores, because mooting is testing your legal analysis and legal knowledge, not just your logic aspect of things. Coming to the opinions part of it, like I have been saying, this is not a debate. So you cannot, and even in a debate, ideally, you should not be giving your personal opinions. It should come on the basis of either the statement of facts provided or on the basis of the rules itself, that is the law itself. So anything that you state, especially in the oral round, always has to be backed by an authority. If you think that you might get away with it, that's not possible, because the judge can always question you and ask you to supply a authority or supply a case law to the effect of whatever you have been stating. So you avoid using terms like I believe or we believe. To be very frank, the judge doesn't care. So you need to actually give them an authority case law of why they should be considering that kind of an argument. Coming to the second part of my presentation, answering questions. Now, to be very honest, guys, if you've actually prepared a speech of, say, about 10 minutes, 85% of the time, you're not even going to finish the entire speech. That is because of the number of questions which are being thrown at you during the course of the oral rounds itself. Students who have been mooting must be very affiliated with this, but this is something for the benefit of the first years especially, that do not be disheartened if you actually do not finish your speech. That is very, very normal. And it is more often than not the case. So when you are presented with a question, to understand how to answer it to your benefit, you need to first identify the question in itself. When I say this is something you will get with experience, but just for your understanding, the questions are largely of two types. One is to throw you off your course. This is the most often type of questions which are actually posed before speakers, just to test their legal knowledge, to test whether they know what they're talking about, and to derail them and see whether they can come back to their submissions. And the second type of questions which are given to you are essentially to assist you. So now when you are fumbling during the course of your oral round, the judge might actually pose a question which will help you get into the direction of submit delivery for the oral round. So when a question is posed before you, do not take a hostile attitude or a defensive attitude. The questions are there because that's what the judges are there for. They are here to test your legal knowledge. So in a situation where you're unsure, you can always find a way around those questions, and that will come with experience. So don't really worry when questions are being thrown at you. It's really, really normal. Now, in reference to point 2, by differential opinion, it is basically that when you're given a moot proposition, you ideally have about 2 or 3 months of time to research, frame your arguments, and then come to the oral rounds. While the judges might have been given the moot proposition 1 week before the competition in itself. So that means that there is a possibility that whatever question they're asking might have zero relevance to what you are saying or to the facts in itself. At this point, you need to actually disagree with the judge. So you need to understand how to frame that sort of an argument where you are saying that the question isn't relevant, but at the same time not being disrespectful towards the authority of the judge in itself. So you can say something like, while that is a very interesting point, Your Lordship, in that particular case, the facts varied, or in that particular case, the court actually has given this kind of judgment. So you can learn to find your way around it, or you can refer them back to your memorial and make them go through that. Third is the use of materials. Now, materials includes both your memorandum as well as your compendium. To explain compendium in the easiest is basically it's a compilation of all the authorities that you've used, especially in your oral argument. So all the statutes which are relevant to you, as well as all the case laws that you have used. If you don't want to make it too cumbersome, because especially when you're printing it out, it's actually going to be a huge compilation. You can take the first page of the case as well as the relevant pages. So you can, in that way, submit it to the judge. The reason that compendiums are actually paid a lot of emphasis to is to show that you know what you're talking about and that you have actually done some kind of research. In virtual moots, compendiums is not something that many people pay attention to because obviously it's very difficult to download so many judgments and to frame it. So in virtual moots, it's not that big a deal, but in the case of a physical moot, especially you will see this with the experienced teams, they actually carry these huge books which have annotations, etc. on them. All that is just the compendium to show the judge whenever you're referencing to a case. It is very important you do this because it shows that you've actually done some research work. Plus, it always helps you during your own arguments, because if you fumble anywhere, you obviously have the materials right there. Also, this might be a little late to remind you, but in the physical moots, you're not allowed to carry any electronic devices. So you don't have your phones, your laptops, nothing. So you just have the written materials. That's why the speech that you drafted, you take a printout of it or you handwrite it, whatever is comfortable for you. But yeah, this might be a good time to remind you guys of that. This is all in physical moot, guys. In virtual moot courts, there's very less the organizers can do in respect to this. Coming to the types of answers. So keep in mind that this entire question answer session that I've just told you about is counted within your speaker time. And in a situation where you're supposed to explain the facts of the case, you're supposed to deal with the arguments that you are dealing with, the issues that you're raising, it is very important that you give the answer in as short as possible and get away with the questions as soon as possible. So easiest would be if you have a yes or no question, just answer with a yes or no and then move ahead. Second is always to make them refer to your memo. So when you are saying any argument, you can say that this has been referenced to in the memorandum at page 14, paragraph 6, whatever. So you can frame it that way so that the judge can go back to reading that and instead of pestering you on that part, but always answer the question. Reference to the facts is again an easier way to go about it. Precedent basis is use of case laws, obviously, and analysis would require a little longer time, but try and keep the question answers as short as possible because that is counted within your speaker time. Coming to the third part of my presentation, the general tonality that you need to actually maintain throughout the course of your oral arguments. Firstly, and this is perhaps the most important, always be respectful. It is the judge's court. So whatever they tell you, you need to do that. Even if you think it's not relevant, you still need to do as the judges say. Do not irritate and annoy the judges. This is usually done when you talk over them or you do not give them fair opportunity to ask questions and everything. So do not do all that because it's costing you marks. You need to be confident but not arrogant. This is especially important to understand because these judges are actually advocates themselves, in some cases even sitting or former high court judges. So you need to have a confident tone, sure, but do not be arrogant. While delivering your submissions and answering questions, it's okay to answer, it is actually important to answer all questions, but remember that it is your submission. So do not get so held up in answering that you forget what you are supposed to be telling the court. Always keep that in mind. Like I said earlier, also it is, do not give your opinion. Always use a case law or a relevant citation that might help you out. Reading the bench comes in handy, especially while understanding the kind of questions as well. So in most moot courts, you have a good cop, bad cop strategy. So you will have a judge who is very actively involved and pestering you with too many questions, and one judge who is more friendly and is just asking you the most important questions. So understanding the bench is also important because it helps you understand what are the more important questions you need to pay attention to. Do not lose your temper or concede the argument. This is from a personal experience, and that's why I've added it. In my very first year of mooting, I did get a little too nervous and eventually ended up conceding the argument. And the judges later explained to me that, that is not something that you should be doing, irrespective of whatever, try and continue with your argument, because that's just what you're supposed to do as a speaker. Be flexible to the demands of the bench. So you do whatever the bench is asking of you. And lastly, always maintain a professional conduct and follow all the court mannerisms, especially when the opposing side is speaking. So once you're done speaking, it's not that you can just, start talking or something. It's still a courtroom. You still need to give the same level of respect to your opposing counsels. So you are marked on this as well. The last part is about mooting linguistics. Obviously, this is something that you will pick up as you are mooting. And in the most ideal situations, never use the phrase that I don't know. In any context, never use it, especially while the oral rounds are going on. But if it is a situation where you have no clue of what is going on or what the judge has asked, you can always say the counsel pleads ignorance and ask the assistance of the judge itself to further answer the questions or to just escape the question in itself. Instead of thank you, you would obviously say much obliged. Like I said earlier, I suggest all that are not phrases that is apt for mooting. You would say that it may please your lord to know that, or it may be noted that. And like I said, the judge is always sometimes friendly, actually not always, sorry. Sometimes the judges are friendly and are helping you. So in that case, always respond to them by acknowledging their help. And lastly, as opposed to the pop culture references, you do not refer to your opponent as my opponent. You would always refer to them as their stature of respondent or petitioner. But like I said, these are stuff that you pick up while you're mooting. Initially, this might help you out, but later on, there's many more different kind of phrases that you will pick up once you do start mooting. And with that, I have come towards the end of my presentation as well. Yeah.
Thank you, Himali and Diksha, for those wonderful presentations. We can now move on to the Q&A session. You can either raise your hands and unmute yourself, or you can key in the questions in the chat box. We'll address them one by one. We have one question from Ram Sheshan. Diksha?
Okay, thank you for that question. How would you argue in jurisdiction? So if are you talking in terms of statement of jurisdiction? Do you want to know how do you address a statement of jurisdiction? Or are you asking how do you question whether or not there is any sort of, whether or not a person has a right to come before a court or not? Okay. So if it's the first case where you're just stating out what is the statement of jurisdiction, in that case, you just mention that it may please this court to note that the counsel has approached this forum. This is for the petitioner side, that the counsel has approached the forum under Article 32 of the Indian Constitution, and leave it at that. Unless the judge asks you to go into it, you don't need to specify what is Article 32. When it's the latter case where you're saying that where the jurisdiction is not valid, this is something that you would use in terms of, as a petitioner, all you would say is that the petitioners have come under Article 32, and you have other concepts. I don't want to get into too many terms, but something the local standard and maintainability. So in most cases of moot court, the first issue is always whether the judgment is made, whether the case is maintainable or not maintainable. So that is where you bring in the question of how is it maintainable, whether under Article 32 there was actually a provision to allow for something like this. So all that depends upon your research again. So, but essentially you would just frame it something like the counsels have approached this court under so-and-so provision of law, and it is pleaded before this court that the petition is maintainable as under Article 32 and as was held in so-and-so case. So try and keep it short, because usually maintainability issues can get a little tricky, is what I would say.
We have a few more questions in the chat box. Before we go to them, we have Soeb who has raised his hands. Soeb, you can unmute yourself and ask the question.
Hi, good afternoon. Am I audible? Hi. So this is, I mean, this was a bit of a repetition from the bridge course, but I just had a question with regards to the IRR and the AMCC. Is it a once a year thing, or is it like once every semester?
It's a once a year thing. And I will address a little more deeper into this because I have been receiving a lot of queries of whether you can participate next year or not. The choice is up to you guys. But the thing is, the reason that we have framed AMCC and IRR differently is to suit your conditions better, because when you directly participate in an IRR, it is more daunting, where you have to go into a team round, you have to actually answer the questions which are very technical and more on law oriented, as opposed to AMCC, where you'll have an comparatively easier time, and it is easier to qualify. Plus, it gives you an entire year, if you do qualify, to attend the training sessions which are organized by the MCS, to attend the various workshops that we will be organizing. So there is a lot more that we do for students who get within the panel, which is, aside from giving them just the license to go and moot for college, we also provide for training exercises, mentorship, and everything else. So that is the reason that we do structurize the internal rounds into AMCC and IRR.
So, sorry, I don't mean to take up too much time, but the AMCC qualifies as like an induction kind of process into the Moot Court Society?
Yes, for the first years, that is the process of induction. For the second years and onwards, it is via the IRR.
All right. Okay. Thank you so much.
Aisha has a question whether we can mention any case law that is not in the memo during the oral rounds.
That is an interesting question, and I'll tell you why. You can actually do that. But to do that, there's one simple thing that you actually need to add on to your drafting memo while you're drafting your memo. So once you have finished drafting your memorandum, you can add something known as a reserve clause. It basically reads that the councils reserve the right to raise any additional issues, rules, arguments during the course of the oral presentation. So this allows you to bring up any additional issue, any additional case law that you've not mentioned in the memorandum, and would allow you a little more room, because you would have a little bit of a space between the oral round and the written submissions. So during that space to actually do research and to develop more arguments if you have, you can definitely use this clause. I think there's a follow-up on this, Joe. I just answered that. You can then continue. Where is this added in the memo is once your arguments advance are done, just before the prayer page is where you would add this page.
Yeah. Next, we can take the question from Steve Manoj. Manoj, you can unmute yourself and ask the question. Steve, if that's taking time.
Yeah, I just wanted to ask, is the AMCC held in online mode or offline mode?
It will mostly be in an online mode this time. We would, maybe next year onwards, we can have it offline, but this year we are most likely going to have it in an online mode.
Karthik has asked whether we should prepare facts from both the perspectives or just one which stays neutral and points out all the facts of the case.
Okay, so here is where oral rounds allow you a little more room. So when you are presenting the facts in an oral, in the oral round itself, you can actually manipulate a little bit, not completely. I'm not saying that you can actually change or distort facts. That's not what I'm saying at all. What you can do is highlight the main facts, because see, a statement of facts which is given to you from a moot organizer is about 20 pages. Not all of them are relevant to you. So you will pick up whatever is the most important aspects. You will highlight that for the court, but you can present it in a manner where it is not exactly neutral. So you can actually frame it from your own perspective, from the petitioner's side, and you can go ahead, because you only get about 45 to 1 minute. You cannot actually narrate the entire facts in that small duration of time.
K.S. Naren has asked, usually in moot cases, the places mentioned are imaginary. If we were to use the IPC as reference in an argument, question A, can we do that? Question B, how do we go about it?
Okay, so how do you do this is, most of them, if you've read the AMCC and IRR prop, I'll keep referring to AMCC and IRR. just for your additional information that it's happening. But if you have read both of these props, there is always a thing which is mentioned that the facts or the circumstances are pari materia to that of Indian laws or that of any other law. So if that is mentioned, then in that case, that is how you can use IPC as it is, and nobody would question you because your facts itself state that it is pari materia. Pari materia is basically same as or equal to that of Indian laws. So you can just go about it as it is. You don't need to change the state name or anything, even in the case law or in any other format. You can just go ahead and use it as it is. Okay, when we are preparing our advanced arguments from the respondents or petitioner side, does it have? I'm sorry, just a minute. I am not very clear about your question, Ram. So if you would prefer to unmute and clarify it a little bit, I think that will be helpful. You could just raise your hand and we'll allow you to unmute. Yeah, you can go ahead, I think.
Yeah, am I audible? Yeah, so my question is basically, the IRO requires us to, do both the propositions of both the memorandums from the petitioner side and the respondent side. So my question is basically, while preparing the advanced arguments or the arguments from the petitioner or the respondent side, there will be several case laws against us or for us. So my question is, let's say I prepare on the petitioner side. Now, can I use these case laws to on my argument on the respondent side? That's my question.
So case laws, how you use them is dependent upon the facts itself. So if it is something that is relevant for the petitioners, I would not recommend to be using it in your oral arguments. But where you can use them is in the course of your rebuttal round. Because you would have researched for both sides, you have an idea whether or not this case law is relevant to you, whether or not what the petitioner or respondent is saying is relevant to you. So in your rebuttal / rebuttal, that's where you can use these case laws and information. And just to give you a little perspective, the reason that we are asking you to prepare from both sides is because there will be a draw of lots to allot the side on which the oral rounds would take place. So if you are allotted as the petitioner, then in the round for the oral rounds, you would be representing the petitioner. This is for the IRR guys, not for AMCC. AMCC, we are allotting the site initially itself because it's for the first years. All right, great. Is there any other questions, anything pertaining to whatever has been said since morning? Also, if you have any questions, you can ask that now, guys.
There is one more question in the chat box. Is there any difference between the roles of speaker 1 and speaker 2?
Yes. So aside from the obvious speaking order, there is a difference between the role of speaker 1 and speaker 2. I touched upon this in my presentation as well, but just to reiterate, speaker 1 also has the duty of telling the facts of the case, to tell the time allotment between the speaker 1, speaker 2, to let the judge know what are the issues that both the speakers would be dealing with, while the speaker 2 has an additional responsibility of saying the prayer. Now, the judge might ask either of the speakers to say the prayer / facts, but in the most general sense, if the judge doesn't ask you to do that, this is the main difference between the roles of the two speakers.
You can raise your hands or key in your questions in the chat box if anyone has any queries. Yeah. Do we get a chance to read the memorandum of the opposition before the oral rounds?
So not sure if this would be done in the internal rounds because that depends. But in the case of external moots, this is done. So depending upon which round it is. So external moots have like at least 3 or 4 rounds. You have the preliminary round, the qualifying rounds, the semi-finals, finals. It's a 2-3 long day event. So if it's the preliminary round, most likely you'll get about whenever your draw of lots is happening is where you'll get the exchange of memorandum, which happens where you get the memorandum of the other team and you can give yours. Yeah, so you can read their memo before that. Okay, so an example of how do you disagree with the judge depends upon the facts of how the question itself is phrased. So you can say something like the counsel would, while that is a very interesting point, Your Lordship, the counsel would like to humbly submit that there is nothing of that which is relevant to the facts right now, because the facts right now deal with so and so, and what you are mentioning deals with XYZ. So you can say something like that. Initially, you don't need to pay so much attention of how do you say all of these things because you will pick it up. So don't worry about it. But you can say something very simple. In a situation where you don't know how to disagree with the judge at all and you just want to get away, you can say that the counsel humbly states that the question of is not of relevance because for XYZ reason. Always give a reason so that it doesn't really seem defensive or offending towards the authority of the. All right, guys, is there anything more that you would like to ask in regards to this session or anything that has been spoken of? So whatever I have told till now is something you would be able to observe soon. Okay, oh, sorry, we have more questions. How can we not concede to an argument which the judge is making and is also correct? So the thing is, the judge will always frame it to seem like you are wrong and whatever the judge is saying is correct. Even if what he is saying is correct, you still stick on to your argument because since you have done research, you would have a sufficient pointers to actually make the judge understand, or you can actually delay the question a little bit. So these are tactics you shall learn later. But you can say something like, Your Lordship, that has been mentioned in the memorandum, or Your Lordship, while that is a very important or pertinent point, that is not exactly what I am trying to say. I am trying to say so and so, and just repeat the answer, repeat the assertions that you have been making. So all of this is something you'll pick up along the way, so don't worry about it. Yes, so just coming back to what I was saying before the question, you will be able to see whatever I have at least presented, the oral rounds part of things in the demo session, which has been organized for you guys. So I would request you to actually pay attention to whatever was said. Do not forget, guys. This is important stuff. So just try and pay attention and see to how the speakers are actually making their arguments, making their submissions, and how they are responding to the questions of the judges and everything else. Meanwhile, if there is anything else that you would like to ask, we shall wait for a couple of minutes, see if there are any questions either on YouTube or here that you would like to ask us in respect to this session or something that has already been told in the first two sessions as well. If there's anything, you let us know. We'll be here.
Diksha, I think we have one more question in the chat box.
Yes, I was just going through that. We can choose who can be speaker 1 or speaker 2, irrespective of the order. No. So in most moot courts, this will be specified in the rule book. If not, it is always best to clarify. The order that you register in is how you follow even during the course of your oral arguments. So the reason that it is important is because it shows the structurization of your presentation, where arguments need to have a proper coherency for the judge to actually give you proper scores. And you are marked on coherency, just to like inform you a little bit. So you are marked on coherency and everything. So you can choose to be speaker 1, speaker 2, but register accordingly. What to do in a situation where due to questions, the time has run out. Do you cut it short and how do you go about it? So you can do two things. One is you simply say thank you and you leave the podium, go and sit. Second thing you can do is you can ask for a little extra time, a minute or two. And if the judge has actually been badgering you, they will allow you that 1 or 2 minutes. But if they do not, then you just leave it. So it is always important to keep a note of the time yourself. The court clerks will be letting you know at brief intersections how much time do you have left. So in that situation, what you can do is to give the most important points, at least ensure that most important points are said. This is why, like I said, prepare a proper skeletal structure so you will know which is the most important arguments that you have to make. Can we change the speaker numbers before the submission of memorials? That depends actually on the rules of each of the moot courts. Some moot courts allow you to do that, some do not. So that really depends on each moot court. Yes, Zoe, we can go ahead.
Hi, Diksha. I had a question just with regards to like mooting in general. Given that, you guys have the experience, I feel like it's fair to ask you. I'm sure everyone here is aware of like Lawseco, Loctopus, so on and so forth. They all have like certain moot schools of sorts. I wanted to ask, are these things worth it? Are these things helpful? Yeah, and I just want to know your thoughts. Is it worth signing up for these courses, especially as like a first year and all, who stands to gain that advantage?
See, it is always helpful to get as much knowledge as you can, but at the same time, I would like to specify that some courses, I would not say which ones, but some are above 5 to 10K, which is not something which is actually worth it, because mooting is also a form of experiential learning. So no matter, they'll tell you the same things that we have told you, maybe a little bit in depth, maybe in a little bit differently, maybe some advocates might come over and talk to you about all that, but essentially mooting is something that you learn through experience. That has been at least the case for all of us. We don't have, at least we don't have the entire ideology to subscribe to such courses, but it is always dependent upon yourself. If you think it will help you, then surely go ahead and do it, because it gives you additional practice. It gives you networking. I would not deny that. But at the same time, just take into consideration with regards to cost and everything, whether that is something you want to invest in. So yeah.
Makes sense. Thank you.
All right, guys, I don't think we have more questions. If you do have questions, I am anyways here till 1:30. So we will be posting the attendance sheet for the last hour now. Kindly fill that in. All of us are here till 1:30 at least. After that, we have a 1 hour lunch break, and then we will move on towards the session, which is the demo move session. And I really recommend all of you at least participate and have an idea of how the mood code actually works as. And yes, I will be posting the link right now for your for you guys to fill it in and everything. And yeah. Yes, you can leave if you have no questions, but please join in the meeting back by 2:20, which is where we'll be starting the next session. So if you do not have any questions or anything, you can leave. If you want to stay back to interact or to ask questions, you can do that. The next session will begin at 2:30. So you can join in at around 2:20. We will start the session. Also, guys, please take note. I see many of you are sending me messages to later on allow you to fill in the attendance form. So that is not something I would be able to do or any of us would be able to do. Kindly ensure that you fill in the form. We will be closing the form at 1:35. On YouTube, we will post the link soon. Just give us a minute.
Good afternoon, everyone. Thank you for bringing a great audience today. Before we begin with our next and final session, kindly adhere to the following pointers. Kindly refrain from asking questions during the oral presentations. Questions regarding the procedures will be encouraged and taken after the oral round is done. We hope you have read the proposition which was circulated on all the class groups. However, if you haven't, kindly go through the AMCC Prelicio proposition during the oral rounds. Before we proceed, these are the brief facts of the case. Radha and Sarla are transgenders. Sarla had undergone sex reassignment surgery. Shocked by the transition, Sarla's family delivers threats to both Radha and Sarla. They get married according to the Hindu Marriage Act. A pro-binary gender family organization called Kurumba Samiti approached the High Court to have the marriage nullified, and the High Court ruled in favor of the organization. Radha and Sarla are now appealing before the Supreme Court. For clarification purposes, the meaning of some of the terms in the proposition: nullification of marriage means a legal procedure which cancels the marriage between the spouses. Annulling a marriage is as though it is completely erased. Appeal means appeal is to resort to a higher court by way of filing an appeal to review the decision of a lower court. Appellants: the parties in the appeal are appellants. Kindly keep in mind that appellant in High Court is not an appellant in Supreme Court. The opposing party will become the appellant, which means the aggrieved party who goes for an appeal becomes the appellant. Supreme Court, the court of highest authority in India. Here in the proposition, the parties are going for an appeal to Supreme Court to review the judgment of the High Court. Petitioner is the one who files the petition. Respondent is the one who responds to the petition filed. We have Professor Sudeep and Professor Thomas as judges presiding over the case. We have Vijayashree as a petitioner and Tarun as a respondent. We have Rishabh as the court clerk. Now we will have Prelicio, which is a demo mode. Pay attention to the procedures as this will help you immensely in your internal rounds. Over to you, Vijayashree.
Thank you, Simi. The counsel for the petitioner seeks permission to approach the bench.
Permission granted, counsel.
The counsel seeks permission to collectively address the bench as your lordship.
Yes, granted. Permission granted.
Much obliged, your lordship. The counsel seeks clarification on whether the facts have to be presented.
Yes, kindly proceed with the facts.
Much obliged, your lordship. Here are the facts. Radha and Sarla are transgenders. Sarla has undergone sex reassignment surgery at the age of 19. Radha was born male, however, she identifies as a woman. Both are 35 years of age and work together and live together. Over the course of living together, they fall in love with each other. Sarla's family search for her, find her place, and decide to visit her only to be shocked to find her transition. And the knowledge about her relationship with Radha only further angers them. After a scuffle between Sarla's friends and family, the family decides to leave, but only after delivering threats towards both Radha and Sarla. Shocked by such events, both Radha and Sarla become cautious and decide to get married and try to move places as soon as possible. Radha and Sarla, along with their friends, meet at a temple and in line with Hindu customs, get married. As soon as the marriage photos become public, a pro-binary gender family organization called Kutumba Samiti began to harass and threaten the newlyweds that they're violating the institution of marriage and transgenders cannot tie the Mangal Sutra. The High Court held that the marriage is invalid on grounds of transgender not included in the definition of right. The petitioners have approached the Honorable Supreme Court to hear their plea and uphold their marriage valid. The counsel seeks permission to proceed with addressing the issue 1.
Yes, proceed with the first issue.
Much obliged, your lordship. So the first issue questions the definition of marriage under the Hindu Marriage Act 1955 and if it means only between a man and a bride. The Hindu Marriage Act 1955 states that the act applies to any person who is a Hindu. It mentions that a marriage may be solemnized between any two Hindus and also poses certain conditions for a Hindu marriage. Now, these conditions range from the sanity of the marriage, sanity of the individual to give consent, the age criteria, and so on and so forth. Radha and Sarla both fulfill these specific conditions along with the condition that I'll be stating, which is given under the Section 5 of the Hindu Marriage Act. Here's a brief of the 5 conditions given under the Section 5 of the Hindu Marriage Act. Condition 1 being that neither party has a spouse living at the time of the marriage. Condition 2 being that at the time of the marriage, the party should be capable of giving valid consent and should not be subject to mental disorder or recurring attacks of insanity. Condition 3 being that both the parties must be 21 years of age and above. Condition 4 being that they must not be within the degree of prohibited relationship. And last but not the least, the condition 5 being the parties are not sapindas or cousins of each other. When we compare the facts and the conditions given under Section 5 of the Hindu Marriage Act, it is clear that both Sarla and Radha and their marriage do qualify under Section 5 of the Hindu Marriage Act. Now, the statute does not explicitly define a Hindu marriage as a marriage between bride and bridegroom or a Hindu woman and a Hindu man. It merely states the involvement of any two Hindus. Moreover, Section 2 of the said Act does not explicitly prohibit the inclusion of transgender men or women. Moving on to the definition of bride and groom, the definition of bride and groom must be made on the basis of what's happening in the society in the present day scenario. The words man and bride from the Act will have to be interpreted broadly according to the societal conditions and a gender spectrum analysis. The Blackstock Dictionary defines a man as a human being, hence broadening its purview. The expression bride occurring in Section 5 of the Hindu Marriage Act 1955 cannot have a static or an immutable meaning as laid down under Arun Kumar versus the Inspector General of Registration. The court is free to apply the current meaning of a statute to present day conditions. In fact, it becomes necessary to amend and interpret statutes as per the changing times, because not only are the people changing, but so is their thinking. In fact, the Hindu Marriage Act begins with an act to amend and codify the law relating to marriage among Hindus, hence throwing light on the amending aspect of the marriage between Hindus. It must also be noted that there is a violation of the article. Yes, Your
Just a
Lordship.
minute, dear counsel. With regards to the preface, the preamble that comes to the Hindu Marriage Act, the Hindu Marriage Act, can you say the preamble once again? To amend and?
Your Lordship, it states as an act to amend and codify the law relating to marriage among Hindus.
Precisely. So here when you say amend, the word amend will have to be taken to the context of the law that was already there before 1955 with regards to the laws of marriage pertaining to the Hindus. That will have to be the context in which you apply the Hindu Marriage Act.
Yes, Your Lordship. Counsel pleads ignorance.
Then with regards to the religion of the parties, you have not made a submission that they are Hindus.
Yes, Your Lordship. Much obliged for the question. So, Your Lordship, the facts of the case state that parties go to a temple and get married in line with Hindu customs. So, Your Lordship, this implies that both Radha and Sarla adhere and follow the Hindu religion. So, we can infer that they do follow the Hindu religion from the facts of the case itself.
Is it because of the fact that they have followed the customs, or is it because they follow it at the temple?
Your Lordship, the facts do not clearly mention if they follow all the customs, but what the council can infer from this aspect is that they try to validate their marriage with the Hindu customs. So it should infer that they do follow the Hindu religion.
But there are Hindu customs that are being followed in other communities as well, isn't it, counsel? If you take the Christian communities, there also they do have certain customs that are very similar. So is the custom the sole determinant factor in saying that the marriage that is being performed is a Hindu marriage?
Not really, Your Lordship. I think the council thinks that even the fact that they went to a temple, that also states the fact that they do follow the Hindu religion. If they had followed the Hindu customs that are common with other religions, they would have gone to another institution for that matter. But they chose to go to a temple, and that's why it can be inferred that they do follow the Hindu religion.
Okay, so following up with regards to Hindu religion, now the Hindu religion, when we analyze Hindu law as a subject, there are different schools of Hindu law. So which school of Hindu law do the parties other to have they disclosed to you which school of Hindu law do they follow? And because of the virtue of following that particular school of Hindu law, that they seek a registration under the Hindu Marriage Act.
Your Lordship, there are a couple of schools of Hindu law. What I can think of is Dayabhaga and Mitakshara. And answering your question, it is Mitakshara that they are adhering to for the purpose of registration.
All right, Counsel, you can proceed.
Much obliged, Your Lordship. So it must be noted that Article 14 of the Constitution of India affirms that the state shall not deny to any person equality before the law or the equal protection of law within the territory of India. That means when consider the purview of any person, it must include transgender persons as well. Therefore, they must not be denied the aspect of equality before law and equal protection of law just because of their sexual orientation or their gender identity. Moving on, it must be noted that there is also violation under Article 21 when we interpret the term or the words man and bride in a very strict or a stringent sense. We infer the violation of a person's personal liberty, or in fact, Article 21 aims at protecting the dignity of human life or one's personal autonomy. In fact, it is given or laid under National Legal Services Authority, which is Union India, which states that one's right to privacy and dignity is a very integral part of Article 21. It must also be noted that under Suresh Kumar Kaushal versus Nas Foundation, it was stated that popular morality or popular opinion must not be considered as a valid ground for prohibiting anybody from exercising their fundamental rights. And therefore, it does not make sense to not give or enforce rights of transgenders just on the fact that the society does not approve or the popular opinion says otherwise. There
Counsel,
is also
Counsel,
yes, Your Lordship.
is there anywhere in Indian laws you can find a definition for the word transgender?
Yes, Your Lordship. The National Legal Services Authority versus Union of India had defined the definition of transgender.
So what is the basis of identifying a person or his legal rights, like man's legal right or women's legal right, if that person is claiming to be a transgender? What can be the basis of that?
Your Lordship, can you please repeat the question?
For example, if I'm a transgender person and I would like to get, suppose, a right available to a man in Indian laws, what is the criteria?
The council please ignorance, Your Lordship.
Okay, continue.
Yes, Your Lordship. It must also be noted that there is the Article 25, which professes freedom to practice and propagate one's religion. It confers it to all persons and does not prohibit anybody from exercising their right under Article 25 only on the basis of their gender or sexual orientation or caste or so on and so forth. Therefore, it should imply that the right to religion or to right to practice one's religion must extend to transgender persons as well, and therefore prohibiting any person with respect to their gender or their gender identity for that matter will be a gross violation of the spirit of the Constitution and of Article 25. It must also be noted that the Universal Declaration of Human Rights, the Article 16...
Counsel, just 1 minute.
Yes, Your Lordship.
When coming to the purview of freedom of religion, how do you interpret a marriage, a union between these two persons as essential to religion? Can you explain upon the religious aspect that is associated over here?
Can you please repeat your question, Your Lordship?
You are saying that there is a violation of freedom of religion, isn't it, counsel?
Yes, Your Lordship.
Yes. So when we say freedom of religion, there are certain essential religious practices that are to be performed to assert that that falls under the perspective of freedom of religion. Yes.
Yes, Your Lordship.
So how would you like to see this relationship as fundamental to the religion? Now, see, marriage, it is having a lot of contractual implications as well. But why is it so particular that they want it under the Hindu Marriage Act? Why can't they take a provision under the Special Marriage Act?
Your Lordship, the purpose generally why the Special Marriage Act, people register their marriage under the Special Marriage Act is when it comes to interfaith or interreligious, interreligion cases. But in this aspect, both of them are Hindus, and that's why they want to apply under the Hindu Marriage Act.
But the Hindu Marriage Act, as the Hindu religion actually provides and it affirms that there is a sacramental reverence given to the institution of marriage, isn't it?
Yes, Your Lordship.
So will that apply? Is it possible to infer that sacramental reverence to a union of this kind?
Your Lordship, as far as I know, I don't think the Hindu law prohibits transgender persons to get married and so on and so forth. So I don't think it should come under that purview, or it should not be implied that way, Your Lordship.
Is there any other basis apart from your personal inference?
No, Your Lordship.
All right. So you are asserting that Article 25 is being violated because they are Hindus and they are being prohibited from the exercise of their right to practice their religion. Is that what you assert, counsel?
Yes, Your Lordship.
All right. You can proceed to the next portion of your arguments.
Yes, Your Lordship. The counsel seeks permission to address the issue too, briefly.
Okay. Can you tell us what is the second issue you have identified?
Your Lordship, the issue too is does the definition of bride under Section 5 of the Hindu Marriage Act include transgender?
You may proceed.
Much obliged, Your Lordship. So the term bride occurring in the Section 5 of the Hindu Marriage Act cannot have a strict meaning, as already laid under Arun Kumar versus the Inspector General of Registration. If it has a very strict meaning, then it infers that it is violating the rights under Article 14 and Article 21. In fact, the right to marry has already been stated as an integral part of Article 21 under Safin Jahan versus Ashokan KM. A person's right cannot be violated or infringed just on the basis of the person's gender identity, and it comes under the purview of Article 21 to express a person to allow or to give the freedom to a person to express his or her gender identity as that person may like. In fact, in Arun Kumar versus the Inspector General of Registration, it was held that a statute must be interpreted in the light of the legal system as it exists today. That means it indicates that the term bride must include the term. It should be broadened and it should include the term transgenders as well, as it should apply, as a law should apply as to what's happening in the present societal conditions as well. The counsel humbly submits arguments, and the counsel seeks permission to proceed to the prayer.
Counsel, with regards to the identification of the perception, you said under Section 5 of the Hindu Marriage Act, I think in Arun Kumar's case versus Inspector General, you are asserting that there was an interpretation of the word woman, isn't it?
Your Lordship, yes, Your Lordship. The definition of bride.
Yes, the definition of bride will include
transgenders as well. It should include
Transgender.
transgenders as well, Your Lordship.
So it will include trans women as well.
Yes, Your Lordship.
So, okay, so one of the petitioner in this case would, will be applying. But with regards to that case, one person identifies as a trans woman and the other doesn't identify as such, isn't it?
Yes,
Can you
Your Lordship.
elaborate on the case?
Yes, Your Lordship. So
Isn't
the
it?
fact that, so, pardon,
You can
Lordship?
elaborate on the facts of that case. Arun Kumar versus Inspector General.
Yes, Your Lordship. So in Arun Kumar versus the Inspector General of Registration, the petitioners get married at a temple as per the Hindu rites and customs. So the village administrative officer certifies the performance of the marriage. However, the temple authorities decline their marriage, and that's why the parties or the petitioners come forward and ask for the marriage to be held valid and the registration to be valid as well.
So there were no ceremonies performed in the temple?
Your Lordship, there was. The petitioners get married at temple. That's why there were the rites and customs were performed. But later on, the temple authorities declined to watch for it.
So that means they declined to communicate to the marriage registration authorities. Is that what you're asserting?
Yes, Your Lordship.
Okay, and what was the relief provided?
The marriage was held valid, Your Lordship.
The marriage was held valid. Okay. Yes, counsel, you can proceed for the prayer.
Much obliged, Your Lordship. In light of the arguments advanced, the counsel for petitioners humbly requests the Honorable Supreme Court of India to adjudge and declare that the marriage is valid and it does come under the purview of Hindu Marriage Act 1955. It was an honor arguing before the Honorable Supreme Court.
Counsel for the respondent?
I hope my audio is audible, Your Lordships.
Yes, it is.
The counsel seeks permission to approach the bench.
Permission granted.
The counsel, much obliged, Your Lordship. The counsel seeks permission to address this bench collectively as Your Lordship.
Permission granted.
Much obliged, Your Lordship. The counsel now seeks permission to proceed with issue 1. Your Lordship, issue 1 deals with the question on whether the definition of marriage under the Hindu Marriage Act mean only between a man and a bride. The counsel for the respondents humbly submit that several sections of the Act and multiple judgments of the Honorable High Courts often refer to Hindu marriages as between a male and a female. There is no specific mention of a marriage between a man sorry, Your Lordship, there is no specific mention of a marriage being between a man and a bride in that particular order, fashion, and sense. In fact, Section 3 of the Act specifies the definitions of the Act, and Section 3, Clause F, particularly under Subclause 1 of the Act, particularly defines subinter relationships, which is basically described as the lineages of fathers and mothers. This helps us understand that Hindu marriages mean only between a male and a female, as male and female are denoted as father and mother respectively. This understanding, Your Lordship, can also be seen in the case Amarendra Man Singh versus Santana Singh and others, where it is noted that a marriage is between a man and a woman. Similarly, Section 5 of the Act lays down the conditions for a Hindu marriage, and Clause 3 of the Act specifies the age limit of bridegroom as 21 years of age and the bride as 18 years of age. Here we can clearly see the usage of bridegroom and bride for a male and female respectively, Your Lordship. In fact, similarly, Section 7, which deals with the ceremonies for a Hindu marriage, further mentions bridegroom and bride, particularly in Clause 2 of the section. In fact, including the references of husband and wife can be seen in several sections of the Act, such as Section 9, which deals with the restitution of conjugal rights. Your Lordship, these terms of bridegroom and bride signify a husband and wife, or in other words, a male and a female, as mentioned in almost all of the cases that are cited and will be cited, Your Lordship. This is also seen in the Hindu Succession Act 1956, Child Protection Act of 2006, among many other legislations. The counsel now requests permission to proceed to the next issue.
Counsel, can you elaborate me on the Child Protection Act of 2006? What
Your
is the
Lordship,
legislation about?
Lordship, the council in this reference has only made use of Child Protection Act to understand that whenever the Honorable High Courts have used such legislations, they have mentioned a marriage between a husband and a wife as a male and a female. There is no specific indulgence laid down into the Child Protection Act, Your Lordship.
Now, with regards to considering the position of individuals, the identification of persons, there are already certain orders that have been issued, that have been declared by this Honorable Court, conferring certain rights upon persons. And the expression person has been pretty wide to include any individual being born as male or female, or having any perception as well. So there are no restrictions over there. So pursuant to the prior orders that have been issued by this court, has there been any steps taken by the state in recognizing further rights and obligations under the law?
Your Lordship, this is in reference with transgender persons, right? Whether there have been rights issued to transgender persons.
Precisely.
Certainly, Your Lordship. In fact, the latest legislation on transgenders has been a broader approach into their rights and freedoms. However, as the Council will further mention in their arguments, it can be seen that marriage has not been allowed specifically, in fact, deeply in the Hindu Marriage Act itself. If I may be allowed to proceed to the next issue, this will be elaborated on detail, Your Lordship.
There is another thing that comes. The Hindu Marriage Act is actually a legislation under personal law. So when the Hindu Marriage Act is a legislation under personal law, and when a person is a practicing Hindu, so why not allow them to register their marriage under the Hindu Marriage Act?
Your Lordship, that is right. It is true that the Hindu Marriage Act is made to regulate marriages between Hindus. However, the understanding here is that when we look at the second issue as well, it is regarding whether transgender persons can be included under the Hindu Marriage Act or not. And the councils for the respondents humbly submit that the definition of bride in Hindu Marriage Act does not involve or include transgender. Specifically, Your Lordship, if you look at Section 3, Clause A of the Hindu Marriage Act, it specifies the meanings of customs and usages as any rule which have been continuously and uniformly observed for a long time among Hindu tribes, community, group, or family in any local area. So in order to fully understand why these customs and usages, or what these customs and usages mean, the sources of the Hindu Marriage Act and other Hindu laws must be examined by us thoroughly, even in order to understand why transgender persons are not included under the ambit of Hindu Marriage Act. Your Lordship, among several sources and commentaries lie the Vedic scriptures that provide a concrete understanding of various customs, practices, and usages of Hindu traditions, which have influenced and guided the Hindu Marriage Act throughout the decades. In fact, even during the preparation of the Act, Hindu marriage occupies a predominant place in Hindu tradition, Your Lordship. If I may quickly elaborate on this, Your Lordship, according to the Vedic scriptures, marriage can be defined as a religious sacrament in which a man and a woman are bound in a permanent relationship for physical, social, and spiritual purposes for attaining dharma, procreation, and sexual pleasure. This relationship is thought to be a permanent relationship between a man and a woman, and the female wife is considered as the greatest friend of a male husband. Procreation is one of the three primary aims of Hindu marriage, Your Lordship. Manu, who is the eldest son of Lord Brahma, wanted to establish codes to regulate human conduct. And he then drafted the Manusmriti, according to which the primary aim of marriage is to procreate. That is the most important, or one of the most important aims of marriage. This is to ensure that life energies are only directed towards conceiving a child, and this can only be legitimized through the process of marriage, Your Lordship. Yes, Lordship.
What you mentioned is clearly from Puranas, from the mythology. It may be true, but do we have to accept these ideas formed? I mean, in ancient times in today's practices? Or do we need a new approach considering the changing circumstances? What do you think?
Certainly, Your Lordship, you are very right in understanding that. In fact, those are one of my future points where it may bring on question what relevance do these societal beliefs and ancient sources hold in the modern world. However, these cases are still seen in modern case laws as well. If you look at Manju Thakur versus Rajkumar, or other cases such as Rekha Kumar versus Manish Khanna and Kirti Nagpal versus Rohit Gidwar, all of these cases, whether directly or indirectly, make use of references from Hindu sources or ancient Indian sources, ancient Hindu sources, which are largely part of human relationships across Hindu marriages today. In fact, if you look at if you look at cases such as Kirti Nagpal or even Rekha Mothur case, mostly the husband has been sought for divorce under Section 12, Clause 1, Subclause A of the Hindu Marriage Act, due to the reasons that the marriage has not been consummated owing to the impotency of the respondent. So these, as you can see, these are modern case laws which were decided in the last few years or the last few decades, where principles mentioned in the ancient Hindu sources have still seem to influence Hindus in individual state today. So, right. So in that sense, although we have seen exceptions, whereas the Vedas specify transgenders as Tritiya Prakriti or the third sex, they are mostly living in relationships, and all the other rights and freedoms were provided to them. Just that while they've practiced, occupancy or celibacy, however, the marriage was not considered as legal or valid because for two reasons. First of all, for the sole reason that they cannot procreate for future children. Second reason is that children born out of this sense of fear tend to be scientifically proven to be unhealthy children or unhappy children. So when a society has been formed in such a way where there are so many ancient traditions,
Counsel, just a minute. Where is the issue of children being out of fear comes in this case?
Your Lordship, this is just an explanation to understand that it was an ancient Indian belief. It was an ancient Hindu belief in Hindu societies that any intercourse made through fear would lead to the birth of unhappy children. Now, if the marriage of the parties in our case is concerned, if they are allowed to get married and if they are allowed to understand marriage as understood in Hindu Marriage Act, first of all, they would not be able to procreate future children. And even if they if there was any source of whether it is scientific means to procreate children, it was seen that the children wouldn't be happy children as they grow up. This was just an ancient Indian Hindu belief, Your Lordship.
So you don't
is
take
there
that belief? Sorry. Okay, you don't agree with that belief, or do you agree with that belief?
Your Lordship, the council is purely placing points to solidify the fact that the marriages cannot be understood as legal, specifically in Hindu marriage.
I'm asking because what's the relevance of such beliefs in this court?
Your Lordship, with the reference, as far as relevance is concerned, as the council was already stated that the modern cases involve these conversations, these understandings, and these perceptions that have solidified throughout the generations. And since we are only talking about the Hindu Marriage Act and whether the marriage is valid under Hindu Marriage Act or not, I think it becomes important for us to understand the sources, and not as the most important, however, it does help to a large extent to understand why the Hindu Marriage Act places the points it does place. Because if you look at exceptions as seen in what the petitioner council cited, the Arun Kumar versus Inspector General case, where the court did include transgender in the ambit of bride, but it made clear that it was not a groundbreaking case as it merely stated the obvious. In other words, it can be Arun Kumar case can be considered as one of those exceptional cases, and only marital rights were denied to the transgenders owing to the simple fact that they cannot procreate, Your Lordship.
Counsel, you have 2 minutes left.
Counsel can continue.
I'm sorry, Your Lordship, could you repeat what you just said?
You can continue. You can continue.
Yes, Your Lordship. The council now seeks permission to proceed to the prayer.
Done.
Permission granted.
Much obliged. In light of the issues raised and arguments advanced, the Council for Respondents humbly requests the Honorable Supreme Court of India to adjudge and declare that the concerned marriage is invalid and does not come under the purview of Hindu Marriage Act 1955, based on the arguments and the points involved. It was an honor pleading before this Honorable Court.
Thank you, Tarun. Thank you, Vijayshri. Thank you, judges. We shall now proceed to question and answer session. Participants, you can key in your question on the chat box or you can raise your hand. Questions will be noticed and it will be taken up for it to be clarified.
Yeah. Hello. Am I audible?
Yes, go ahead.
Yeah. At the last of the prayer, right? If you are the respondent's counselor, if there is a judgment from the High Court, could we add a statement in our prayer saying that to uphold the judgment, the council requests the court to uphold the judgment of the High Court as well on the statement? Hello.
Yes, we can hear you. Just repeat your question if you can. I'm sorry.
Yeah. Okay. So my question is basically at the last of the prayer, right? If you're the respondent's counselor and there is a judgment in favor from the High Court, just as this case was, could we add in the statement saying that the council requests the court to uphold the judgment of the High Court in our prayer as well?
Uphold the judgment? No. You'll have to request them to pass a favorable order because, yeah, you cannot tell them to uphold a judgment that's there.
Yeah, all right. Thank you.
Any other questions, guys, related to the session?
Guys, you can ask us anything in particular to the yesterday's prolizio moot proposition that we've sent. If you have any terminology that you've not been able to understand or something that we can help you out with, anything you can ask us now with regards to the procedures as well. What you have seen is a simulation of an actual moot court, which would happen in an external or an IRR round. So do not worry or get panicked. With a little bit of training, you will be able to actually perform well and not really be intimidated or anything. The point is that the questions are, like you have seen, sometimes to derail and sometimes to help. So I hope that the session helped, and we would really like if you would like to interact or ask us any questions. Okay, I see a question in the chat box on how do we differentiate with the important facts and non-important facts. So that is something that you decide once you receive the proposition itself. Once you do a thorough reading, I would suggest read it at least twice or thrice. You will be able to identify what are the main events. Like for in this case, the prolizio moot, if you read, there are certain things which are important to the proposition. Whether the person being an intersex, transgender, the fact that they had a surgery, the fact that they are right now married, according to which laws are they married. So you can form a chain of thought and coherence. So this is something you do once you have read the proposition twice or thrice. So that's how I think you will be able to identify what are the important. There are some decorative facts. I think if you read, you'll be able to see that they belong to a good family, they come from this so-and-so background. So all that is a decorative fact, which is not really important for you. So this is how I think is one way you can identify.
For that previous question that Ram had asked me, I was just reminded of two things, like authoritative precedent and persuasive precedents are like two things. So if you are before a Supreme Court, a precedent or a case law of a high court will only have a persuasive value, right? So you cannot go to a Supreme Court and tell the Supreme Court to uphold the high court's judgment. If at all your question was along those lines, this is the response.
There's another question on how many precedents can be stated in an argument. I touched upon it in the previous presentation. Ideally, do not cross 4 or 5. I'll tell you why, because you need to be really thorough with the judgments that you're citing, especially in your oral arguments. With written, you can get away by saying that you are not aware of the facts, or that was not exactly relevant. But if you're citing it in your oral arguments, you need to be really thorough. So I would suggest around 4 or 5 as the maximum. But if you think there are more that can be incorporated and can make it sound good, then this is for the preliminary stage, guys. As you go on to the advanced stage of mootings, you can definitely incorporate as many cases as you think will be relevant.
Diksha, I think you're muted in case you're talking.
Yeah, I'm sorry, I didn't notice that. But yeah, so 4 case laws for one issue is the question. You can do that. There is nothing wrong with incorporating that, but I would suggest to not do that in the oral stages, in the preliminary stages at least, because it will be too much information for you to remember. As you move on to the advanced stages, definitely I would suggest you can take up 4 or 5 case laws per issue as well. You guys can also give your comments on this session that happened if you are not too particular with regards to questions. If there's anything you would like to particularly point out with respect to whatever you've seen since morning and how it played out in the oral rounds, if there's anything you would like to say in regards to that, that is also welcome.
Cyril is asking if cheat sheets are allowed during sessions by speakers for reference. Yeah, during
okay, fine, go ahead.
Cheat sheets, I mean, you just mean normal chits for us to refer to, right? Like, I mean, if you can explain to me what you mean by cheat. Yeah, right. So notes for reference, yes, you can always use them. Even in physical moots, you're allowed to refer to. Of course, you're not allowed to read from it, but you can always refer to something. And in online moot courts, of course, you can have your monitor and screen on and you can refer to it, definitely. But please don't call it cheat sheets. It's just notes of reference.
Like I said, and I think Himali would also suggest the same, always prepare your entire speech and have at least a copy of it, if not at least of the skeletal framework, and you can use that. Right, so I think there was a question on YouTube with regards to whether it is compulsory to refer to a Karnataka High Court judgment or you. There is no compulsion with regards to which judgment you can refer. But like Himali earlier as well pointed out, ensure that it has some kind of an authoritative value. Do not cite judgments. Ideally, do not cite judgments which have only persuasive value, because that does not take you too far.
There is one question, which is, if a moot proposition has a non-factual statement that's being presented as a fact, does the onus lie on the respective parties to adhere to it as a fact? What do you mean by non-factual? Okay, if a moot proposition has a non-factual statement that's being presented as a fact, see, whatever, now I don't know what distinction it may, I mean, whatever is given in the moot proposition is a factual fact for you to have, right? So whatever is given in the proposition, it is for you to adhere to that. If it's given in the proposition, then it means you can use that fact to substantiate your case. That's
Okay, there is another question. there were, in this case, in the demo round that we saw, there was only one speaker, you're right. How will it go on with two speakers and their procedures? So with regards to their procedures, I have already mentioned earlier and I think at length, so I will not repeat that. But with regards to how it will go is that instead of presenting the two issues by themselves, depending on how many issues there are, you divide the issues between yourself and your co-counsel. You will, and then you just proceed as was proceeded today. So there are not much differences in terms of procedures, but just allocation of issues and time would be different. Yeah, Zoe, we can go ahead.
Hi, good afternoon. Firstly, am I audible?
Yes, you're audible.
Yes, hi. So I left a little comment in the chat box. That was more of a comment, not a question, but it gave rise to a question. That being, I know that you touched upon this earlier, Diksha, but again, I'll reiterate what I said. The judge's questions really stood out to me because you're absolutely right when you mentioned that some of them seem to help, like, guide the argument. At the same time, some of them, I wouldn't know how I would have dealt with the same questions had I been put on the spot like that. And my question to you is, in your opinion, what do you think is the best way to prepare for questions like that? Like, what are some common mistakes we should avoid? What are some good things we should keep in mind? And yeah.
So yes, so like I said, and since morning, I think this is a word which we've said about 100 times, but research. I think research will help you a lot when you, because the speakers that spoke today have obviously done their fair share of research, and that's why they are able to present the arguments. And when I say research, like I said earlier, you have about 2 to 3 months to prepare. So ideally, you would have covered a lot of ground in that amount of time. Research can be via books, via online resources, or anything. With regards to any tips with regards to the questions in itself, firstly, like I said, identify the question in itself. Like you would have seen the speakers in this case also identified the questions which could have just been answered with a yes or no. Did that, it moved forward. If you get hung up on these questions and answers, then you lose track of time and you are not able to complete your submissions. So always identify the questions and accordingly respond. So there might be a situation like if you're not aware of it at all, then you can just say the counsel pleads ignorance and move on. If you get too hung up on that part, you will possibly lose out on the future this thing. So initially, I think at the beginning stage, just try to do as much research as you can with regards to the proposition. That's why it is essential that speakers are researchers themselves too. Like though in the mood dynamics, we call ourselves speakers, we have researchers, but speakers have to do their fair share of research as well, because you are put on the spot at the end of the day. So yeah. Are there any other questions or any other comments or anything that you guys require clarity on? All right, guys, we'll wait for a moment or two and we'll see if there are no other questions, then we'll proceed further. If there are any questions with regards to any legal terminology or anything you would like for us to clarify, we'll be here.
I think there's one question on YouTube, which is it okay to mention the names of the case laws while giving references, or should we mention the facts as well in the oral statement or in the memo? So I think this depends. Like if it's an overarching case law, then it's always good for you to go a little bit into the facts in your memorandum and then connect it with your present case. When it comes to oral rounds, usually just mention it because your judges will be aware of the facts of the case. If they aren't, they'll tell you to elaborate on the facts, but don't go on wasting time on elaborating all facts. If you think it's absolutely relevant, then mention it in your oral rounds. Otherwise, don't.
Yes, guys, but the thing is still know the facts of the case, because the judge can at any point ask you to go into the facts of any case and you will have to be prepared for that. So either way, prepare the facts of the case and keep it ready. Okay, there's another question. For the time being, could you tell us on how we can improve our legal English for the memo? So for that, I would suggest that you first read up a couple of sample memorandums, sample petitions as well if you want to. All of this is available on Loctopus, even on our MCS teams if you want to just go through a couple of memorandums, because you will understand what exactly is the kind of English that you're required to actually learn and to prepare for. And the rest of the jargon with regards to mood is something you'll pick up on the way. I am assuming you're either in the first or second year, so you will pick it up on the way. Do not worry about that as of yet. But to just simply improve upon, if you want to, you can read up on that. Additionally, there are books on drafting as well in the library. It's available. I am not sure how many of you can go to the library. If not, just check up online. There are a lot of books which explain the art of drafting. So if that is something that interests you, please go ahead and you can read those. You're welcome. Are there any other questions, anything that you guys would like to clarify with the MCS? One of the main reasons that we have organized the workshop in itself is because we received a little bit of feedback that earlier sessions weren't as paced and they got a little too much for students to understand. So that was one of the main reasons that we organized it today, and we hope it helped at least clarify a lot of aspects with regards to mooting. And if there is anything that is still unclear, you can go ahead and ask us. There's no problem at all. All right, so there's a question on YouTube that states whether India Qanun would be considered as a proper form of citation. For now and in the internal rounds, maybe, but in external modes, it's not much appreciated to take your citations from India Qanun. Since you have access to platforms like Manupatra, it is better that you use these kind of platforms. In fact, when you go ahead to international moot courts, you would have to probably subscribe to STC or something. Because Manupatra is not much appreciated in international moot courts. For domestic moot courts, it is much appreciated to take Manupatra citations because Manupatra also gives you more organized information if you've been paying attention since morning. So it's better that you take up Manupatra citations. There's another question in the chat box. We are inferring something with regard to the fact. Is it necessary stating that in the memorandum? Are you saying that in a situation where you are, okay, so if you are taking a conclusion or inferring something from the statement of facts, is it necessary to state that in the memorandum? So all your arguments and everything do come out from your statement of facts. And in a situation where you are just taking something blatantly from the statement of facts and you are trying to copy paste or something, then you can actually put in a citation saying that it is available in the moot proposition or in the factual matrix at so and so para for the assistance of the judges. So that is something that can be done in the moot memo. If one of the counsels say I infer, is it correct to say so? There is no problem with saying that statement as long as you are able to back it up with an authority. On what grounds are you inferring this and why? So if you are able to do that, then sure, go ahead and you can use that.
You can use any decent language as long as what you are saying, you're conveying it the right way to the judge. If you don't know the meaning of the word, don't use it. But yeah, in this case, I infer was the right, I think it was right to use.
All right, guys, if there is nothing else that you would like for us to answer or anything, then I think we can move forward. Simi?
Thank you, Diksha. With that, we come to the end of the session. Thank you everyone for your participation. Kindly note that the proceedings seen was a simulation of a moot court and not the personal opinion of MCS. We hope you had a fruitful session and have had your queries clarified. I would like to take this moment to convey our heartfelt gratitude towards Father Director S.J. Gerald D'Souza, Principal Ms. Pauline Priya, for rendering all their support and encouragement towards the Moot Court Society, without which we would not have been here. I thank our faculty coordinators, Professor Sudeep and Professor Thomas, for being there in every step of the journey for us to successfully conduct the workshop today. Students, kindly note that a feedback form is posted on the chat box, or it will be. Do fill the form with your correct names, as the names that are on the feedback forms will be taken up for certificates. So the names in the certificate will depend on the feedback forms you submit. Kindly enter your right full name. Now I kindly invite Professor Thomas Andrews for concluding remarks.
Thank you, Simi. So in regards to the Moot Court Society and the skills of mooting, I'm sure with a whole day of activities, multiple sessions of training, you would have ultimately come to the impression that the moot court is an activity that is exclusively based on your intelligence. But moot court as an activity, as an exercise, is not, according to my understanding, it's not exclusively based on your intelligence. A whole day you would had a workshop that was based upon your research skills, your drafting skills, and the presentation of language. And you were also given a hands-on experience on how a moot court experience will be like. But at the same time, the moot court also gives you an exposure into developing a professional relationship. So when you are presenting yourself as a mooter, you are presenting yourself akin to an advocate who represents an office. Advocacy is itself a profession of respect, and the intention of each and every one of you to choose the legal profession should be to assist the courts in the administration of justice. And that is where lawyers play a very important role. It is very important also to not only have a very deep and profound knowledge of the subject which you are presenting before the court, but at the same time, the moot court exercise also provides you the scope to develop very good interpersonal relationships. It is a team building exercise with which you learn to cooperate and collaborate with multiple persons. So being an advocate, you should have an understanding with the client who approaches you for your help. At the same time, you should also have cooperation with your team members as well. So as all of us are not given equal strengths in equal proportions, we should be able to understand that unless everybody works together in one particular team, it is not possible to achieve the objective of the team, which is to serve the client and secure the administration of justice. I hope the exercise which you have undergone throughout the whole day, starting from morning, has helped you in developing multiple strengths. So they have given you a very elaborate sessions on research, on drafting, on presenting yourself, on court mannerisms. And they have also given you a very good introduction into certain legal terminologies which are essential for the basics in participating for a moot court competition. I would hereby like to place on record my deep and profound gratitude to our Father Director, Reverend Father Gerald D'Souza, SJ, for being our source of inspiration for conducting this program. Father has always been careful and meticulous in identifying where the strength of students lie and where we can't, where we don't. And Father is always involved in bona fide efforts in making sure that students are developed to their full potential. Thank you, Father. I would also like to take this opportunity to thank our principal, ma'am, Miss Pauline Priya, for the words of inspiration and her constant guidance and her meticulous efforts which she took in organizing the program, irrespective of her demanding schedule and the challenges we faced. Ma'am was always there along with us to see that all the activities of MCS have been coordinated well and have been taken care of meticulously. Thank you, ma'am. I would also express my gratitude to my faculty co-coordinator, Professor Sudeep, for his valuable guidance with regards to organizing the program. I would also place on record the relentless effort that has been put by each and every member of the MCS, starting from preparing the materials which was been deliberated and discussed way ahead, and from conveying the message to you in most simple and lucid and clear language in such a way that it is so easy for each and every one of us to comprehend on what is the background effort that actually should be taken in preparing for a moot court, and what are the various steps we should take, and what are the various things we shouldn't fall into in preparing for the course of a moot court exercise. I hereby also extend a very good congratulations to all the participants and my dear students for cooperating and making this program a grand success, because the pride of the institution rests always with the students. And it is always important to see that all of you develop not only on the basis of academics, but even we would like to see you evolving into the best legal professionals of this country. Thank you all.
Thank you so much, sir. And thank you so much to our Father Director and Principal, ma'am, for the event today. I hope all the students are now at least a little more clear about how mooting works. We have posted the feedback form for your perusal on the chat box as well as on the YouTube chat box. Kindly fill in the details by 3:40 so that we can wind up with this. And thank you so much for being a part of the workshop today.